not a consent call. Ms. Daphne Nelson, judge, preside.
Please be seated. Good morning. We're on the record 12 CF 1083, State versus George Zimmerman. Do we have the later, newer version of the verdict form with the correct spelling?
I believe so, Your Honor.
Oh, thank you very much. I've got two. Pardon? They gave you two. They gave you two, okay.
And just one slight matter, if we can approach before the court begins, Your Honor.
Sure.
Now, sir.
Yes, please. The jurors here. Yes. Are we ready to bring the jury in?
I believe so, Your Honor.
State ready?
Yes, Your Honor.
Okay, let's go ahead and bring them in. Good morning.
Jurors are present, Your Honor.
Please be seated. Good morning, welcome back. While you're getting your notes in order, I'm going to ask you my questions. If your answer is yes to any of the questions, please raise your hand. During the overnight recess, did any of you have any discussions amongst yourselves or with anybody else? No hands are being raised. Did any of you read or listen to any radio, television, newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do independent research about this case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, tweets, social networking pages, or blogs about the case? Thank you very much. No hands are being raised. Mr. O'Mara, whenever you're ready.
Thank you.
Yes, you may. Yes, you may.
Good morning, ladies and gentlemen. First of all, obviously, as Mr. DeLeon just said, I want to thank you on behalf of Judge Nelson, Mr. Zimmerman, my co-counsel Don West, the entire defense team, the interns who have just given their life to this case for the last year or so, the prosecution team, and without sounding too over the top about it, sort of the citizens of Seminole County, because you've taken on a responsibility that few people have the opportunity to or the obligation to. And even more so than most, because you may not know this, but most trials last a day or two. They don't last several weeks. And it is very few trials, very few where there is enough of a concern that we have to sequester the jury. So you guys have given us not just your attention during the day, but sort of your life for 24 hours a day, even more so in effect than we have. And I appreciate that on behalf of everyone we just spoke about. The whole system only works when it works with you. Strange in the way it sort of happens that we have a system that's been ongoing for a couple hundred years, and we intentionally bring in people who know as little as possible about the system and tell them to make the most important decisions within it. And that's what we've asked you to do. And I have some fears I want to talk to you about in that regard, because when we talked in jury selection and talked about sort of what this process is and how you have to come to us, I used words like unique, strange even, as far as the system that you're now involved in. We're used to it. We do it every day, sort of like doctors with blood. You get used to it as just part of what you do. We deal with things like autopsy photographs and jury instructions and evidence and witnesses who may or may not remember things or may or may not tell the truth, or witnesses who come with biases. And we come into my office and I look at that and I know exactly how to focus my inquiry because I'm a lawyer. I couldn't do it if I was in a hospital, but I can do it in a law office. And yet we ask you to come in and to take on all of our rules and all of our regulations and to apply them as though you've done it all your life. And my fear is that that's a very difficult task that we're asking you to do. Because the reason why it's difficult is you're completely unused to it. You don't know how to apply a standard of beyond a reasonable doubt. You just don't. You don't know how to wait until you go back in that room to have any thought or any impression about how this case has gone so far. It's impossible. We're not really asking you to do that, but we sort of are. Because what we've said to you is, come from your homes, come from your jobs, sit with us for a month. Get rid of, I guess, almost everything as to how you decide things in your life, except bring your common sense. We've talked about that a lot. Leave that outside. Take on somewhat artificial, and by artificial I certainly don't mean inappropriate or improper, and don't want to diminish it at all, but this sort of unusual standard that we're asking you to take on. And my fear is that you will default to what you're used to. You will default to the idea that you make decisions in a split second like all of us do. That you can't help but have a first impression. If I were to walk in today, let's say, and I just as an example, walked in like this, walked in the courtroom as a lawyer, you would just have an impression. What in God's name is he doing with his sunglasses on, and who does he think he is? What's with the pinky ring? I put that on because obviously this case has gotten some publicity. I became known as some pinky ring wearing attorney. It's actually my dad's high school ring. It's never been on my pinky, but that's all it takes is an impression. And we look at people and we keep that with us. So you might have an impression of George Zimmerman. Stand for a second. You might have an impression of him because he's sitting at the defense table. And that maybe, as we talked about, he's not just a citizen accused, but maybe he is a defendant. Maybe he has something he has to defend. Maybe, in fact, that because the state attorney's office has decided to charge him, he has to have done something wrong. Maybe that's an impression that you have. Unfortunately, we're not going to ask you not to have impressions. That's absurd. My fear, as I was telling you about it, is that if that allows you to sort of diminish or minimize your task that you've taken on here, that it works against my client. Because even when we talk about things like common sense, we want you to use your common sense, but be careful with your common sense. And I know it's a dangerous thing to say. Be careful with your common sense, because common sense is the way we run our everyday lives, the way we make those snap decisions that we have to make every day in order to work, in order to live, in order to deal with our children and our parents. I mentioned as an example, driving today. I guess you guys didn't drive today, but we did. You presume people are going to drive in the lane and not just cut you off. It's these assumptions that we make. The problem with it...
Excuse me, I am so sorry. 1 minute.
Okay.
There's Twitter going on.
Oh, nice. Well,
Sorry.
that's okay. I appreciate you noticing.
Thank you. I'm sorry to interrupt.
No problem at all. I think that, we'll wait now because it may have to be restarted, but I'm just going to chat for a bit, so I'll get back to it. My concern is that it may in fact work against my client, because if you start using those same processes that we're used to every day, that just look at things, make a decision, and move on, that subtly and unintentionally you're going to minimize or diminish the standard that has to be applied in this case. And I'm afraid of that for this reason. If you do that, not only is it going to go against my client, and I don't want that, but any verdict you come up with is going to be sort of a compromised verdict, a verdict that's not based upon the standards that you agreed to, and I'm not blaming you for not doing it, that you agreed to, and that is the only way that this system really works. We talked about the difference in civil cases and criminal cases in jury selection. We talked about the fact that if this was a civil case, you would go back in the jury room and say, well, the state wants money, and you just got to decide a little bit more than half, 51%, whatever it might be. And then that's the standard. And we talked that I think that's probably the standard we use in everyday lives. Everything but those most important decisions. Even when the decision is made to move out of state, to come down to Florida, to move your life here. We talked about maybe that's a decision which is sort of similar to a beyond a reasonable doubt. I don't know about that. I think that you make a decision like that, you weigh the consequences, you weigh the possibilities, but you never are certain. You never look at a situation like that and say, I've addressed and resolved all variables, and all variables are resolved in favor of this. What you basically do is you look at it, it's an opportunity or an alternative or a necessity. You figure it out, you weigh what you can weigh, you accept what you have to accept, and then you make the decision. I would argue to you, I would submit to you that that's not what you can do here today. I think that what you have to do is be absolutely vigilant, diligent in looking at this case and deciding it with a standard foreign to you, but one that you have to take on. Now, that doesn't mean that you have to go back there and wrestle over whether or not Officer Ramondo, did he have medals on the right side of his chest when he was testifying or the left side of his chest? That stuff doesn't matter. But what does matter are those significant issues of whether or not the state has proven their case. And on those essential elements and those essential facts, you have to look at that. Because my fear, Mr. Zimmerman's fear, is failing to do that, you will do some of what the state has asked you to do. They asked you to do it in voir dire, when they talked about assumptions, voir dire's jury selection. They asked you to do it in opening, when they yelled those words that you know weren't yelled. They asked you to do it throughout the entirety of their case. So far, they've even asked you to do it in closing. You are not a premise. The judge is going to tell you what the law is. You've heard beyond a reasonable doubt instructions before. I'm going to spend some time on it again. To the extent that my argument or insight or presentation differs from what the court tells you, listen to what the court tells you. If I go too far afield, either the judge or the state will remind me. But within that context, it's a very, very difficult standard. It is one where you have to look at it and be very vigilant to make sure that when you're looking at this case, you're not making the assumptions that help you decide the case. Assumptions presume a lack of evidence, because if you have to presume something, you don't know it. And if you don't know it, it hasn't been proven. And if it hasn't been proven, as the instruction tells you, it's just not there. And you can't consider it. You can't fill in the gaps. You can't connect the dots for the state attorney's office in this case. You're not allowed to. So, I'll give you a couple of examples. They're not utterly significant, but I'll give you a couple of examples. What do you know about George Zimmerman? Well, use your memory, but you know he went to college. You know he's a neighborhood watch, and he lived there for a couple of years. I think you know he's married because we mentioned his wife's name, I believe. You know that his mom and dad are still around because they testified. And you don't know a lot more about him than that. There are a few more things. You'll remember them, and I'm not going to have a complete review of all of the evidence, but you don't know a lot about him. To the extent that there are questions or issues that you don't know about George Zimmerman, we're done with the evidence. You're not getting any more information from the state attorney's office to prove their case against George Zimmerman. Don't assume it. Don't presume it. Don't connect dots. Don't fill in the blanks with anything. I'm not saying that you'll be sinister in doing that. Just saying that no matter what it is, you can't do it. That's when we say to you, this case is to be decided on the evidence presented in court. It sounds sort of grandiose almost. Well, of course, we're going to presume on the evidence in the case. There is nothing else. Well, the problem with it is that if you're not careful, as we do in our everyday lives, you will connect the dots when you're not supposed to. You will fill in the gaps when you're not supposed to. You will make those assumptions, some of which the state actually asked you to do in the closing. You will do that because you know what? It's natural. It is very natural, but not in a criminal courtroom. It is not only unnatural, it is inappropriate. What do you know about Trayvon Martin? Not much either. But you're not supposed to. What happened that day is what happened that day. But what I don't think you should do is fill in any gaps at all. Connect any dots for him either, for any fact, quite honestly, for any witness. If the decision was made by the state not to present additional evidence to you, do not presume. Do not assume, and do not give anybody the benefit of any doubt except for George Zimmerman. Because, one, you said you would, and two, that's the only way whatever verdict you come up with is going to be just, and it's going to be fair. So, one filter, be careful. Address my fear, if you would, by just being careful, just making sure that when you're back there talking and somebody says, well, he's sort of this, or I really think that one other of you just says, I hear you, sort of thinking it too, can't do it. Let's just take that thought, that very natural extrapolation, and put it to the side. And you might say to yourself, since it's the state who carries the burden alone, You know something? That's what the state didn't give us. That's what they didn't show to us. So let's look at the jury instructions and see if it matters. Does it matter where Officer Armando is wearing his medals? No. But if it is a significant issue, if it's something that you need to consider and decide in the case of whether or not George Zimmerman committed second-degree murder, then sit back and say, I have to look at the instructions. And the instructions say that reasonable doubt can come from a lack of evidence as well as it can come from a conflict in the evidence. The reason why we tell you, and you're instructed by the court, that George Zimmerman need not prove anything is precisely that reason. Again, a strange system, anyone with children know that you want to get them separated and you want to get the story from both sides. And then that's the only way you figure it out. And then you know who stole the cookies, who gave the cookie to the other one to cover up the crime, or whatever it might be. You get an idea because you get them both. So why does he have that benefit? Why does he come before you and say, you know what, decided not to testify? And then you get to sit back and go, wait a minute, my assumption is I want to hear from him. Now, this case obviously is different than others because you've heard from him time and time and time again. You've heard from him telling you what happened that night. But you know what? Even if we didn't put on a statement, you still would have to go back there and say, I'm not considering that. Why? Why do we take away that common sense presumption of finding out all the information that we can about a case? Because we've already talked about it. You want to take away somebody's liberty? They got to prove the case. The burden is on the state. And it goes back a long, long way. I've got a quote to talk to you about, a couple of them actually. John Adams, 1770, when we sort of started this experiment a couple hundred years ago. God, I guess it's 250 now. It is more important that innocence be protected than that the guilty be punished. Now, if I stop there, it sort of sounds like I'm asking to let my guilty client go. I'm not. He's not guilty of anything but protecting his own life. But the quote continues, for guilt and crimes that are so frequent in this world that they cannot all be punished. But if innocence itself is brought to the bar and condemned, perhaps to die, then the citizens say, whether I do good or whether I do evil is immaterial. For innocence itself is no protection. And if such an idea as that were to take hold in the mind of the citizens, then it would be the end of security whatsoever. I have a quote from my office that talks about that in a different way from the 1700s in Nenagh, where my family came from in Ireland. I was there to visit, but never was there. But it also talked about, this is not a death penalty case, obviously that was a death penalty case where they were talking about a guy going to the gallows. And the question was condemning somebody and not being absolutely certain as to your decision. And sending him to the gallows, not because he was guilty, but because maybe he was innocent. And maybe he just didn't know. So that's why we have a system that puts so much of a burden properly on the state attorney's office in this case, to make sure that we don't cut any corners and we don't make any assumptions. And this is a compliment to you because Thomas Jefferson talked about you guys about 200 years ago as well when he said, I consider trial by jury as the only anchor ever yet imagined by man by which government can be held to the principles of its constitution. That's you guys. I think he was talking about jurors in general, but it applies to you as well because we talked about living the Constitution. Well, planned or not, you guys are it. You are living the Constitution. And we'll go over a little bit of it, but I talked to you about it already. This is a solemn matter. We don't take this lightly, whether it's through jokes or kidding around, or you see us smiling at each other or whatever. This is a serious, serious matter for Mr. Zimmerman, and it's an utterly serious matter for you. And I don't say that to scold you into acting a certain way, but just to make sure that we don't do what the state has asked you to do on a couple of occasions now. And you know what? You guys figure it out. It's an assumption. Well, what about this? It's interesting in a case like this because I've called this case the bizarro case in my practice because it sometimes seems like it's turned on upside down to me. And not saying that you should agree with that, but just a perspective that I've had in this case. How many could-have-beens have you heard from the state in this case? How many what-ifs have you heard from the state in this case? Well, I don't think, anyway, they don't get to ask you that. I don't think they get to say to you, what do you think? No. What have I proven to you? What have I convinced you beyond a reasonable doubt occurred in this case, so much so that you don't have any reasonable doubt as to those issues that I presented to you? They are supposed to use words like certainty and definite and without question, beyond a reasonable doubt, no other explanation. These are the words and phrases of good prosecutors. I used to be one. I know. I've used them. What aren't good words of good prosecutors are maybe, what if, I hope so, you figure it out, could have been. Because those are the assumptions that please do not make. Do not cheapen your role in this case by doing anything less than holding them to the burden that they said in the beginning of the case they would gladly accept and prove to you. You know, and the upside down nature of it is that's what defense attorneys do. If you really think about it, if you want to know some of the underbelly of criminal defense work, we're the ones who live in could-have-beens and what-ifs. Well, you know what? Here's some reasonable doubt. What if blah, 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 blah. Or, you know, it could have been that it happened this way. And that could have been, that reasonable hypothesis of innocence, we'll talk about that in a sec. Actually, not a sec, it's going to be sometime this hour, I hope. That could have been, that's where defense attorneys learn to practice and words that they learn to bring to a jury. I'm not going to do any of that with you today. I want you to know exactly what happened that night. I don't want you to presume anything. I would like you to presume whatever you can to my client's benefit, because after all, that's what good defense attorneys do. But in this type of a case, we're going to do something that will probably upset or enrage defense attorneys anywhere who are listening to this case. Because at the risk of confusing you, I'm going to take a side trip for just a few minutes. And that side trip is going to be, I'm going to take on the obligation to prove to you that my client is innocent. Something I absolutely do not have to do. It is the opposite. And let's talk about what I mean about that. Because, as you know, the state carries the burden. And I'm going to say that probably another dozen times before we're done. And we love our charts. So I have a chart. I've got a couple of charts for you. First, I have this chart, which tells you what reasonable doubt is. At least it's my argument as to what reasonable doubt is. I think there's an objection before I show it. It's just you want me to block your view of the jury?
That's fine, go ahead.
Do you want to use the other?
Yeah, well, if this doesn't fix itself in just a second, that might work. Thank you. I have this one. Thanks very much. I appreciate it. I'm going to use that for something else, I think. Thank you. Graphic understanding of what reasonable doubt is. And if it's wrong, Mr. Guy is going to come up and talk to you when I'm done. let him point out where it's wrong. And then you can make that decision. But this is what we've talked about. What might happen? And how convinced you might be. Easy, just not guilty, proven. Highly unlikely, less than likely. I think you get the point. I can read through it and ask you to nod your heads in agreement for each one. But the reality is, until you get to the idea, the concept of guilt beyond a reasonable doubt, then you just don't get it. And what happens if you don't get here? What stays in place? It's not a civics exam, but that presumption of innocence that we talked about never dissipates, ever. The presumption of innocence never dissipates until the state proves their case beyond a reasonable doubt, which really makes sense. It took us from the king's days where he decided if you were guilty or not to your days where you get to. So this is what happens in a criminal case. The state has to take you from somewhere down here before there's any evidence, and he's sort of presumed to be not guilty, all the way up the list in your mind, so that you have no doubt to which you can attach a reason, or no reasonable doubt, to the essential elements of the crime, and that George Zimmerman is guilty of second-degree murder. Now, I said to you that I was going to tick off all of my brethren and sisterin, you call it that? Because what I was going to say to you, I was going to spend a few minutes doing something else. I was going to show you or prove to you, and I've got not just my little conversation with you, but we'll start talking about evidence in a minute, of this. I'm sorry, just a monster. Again, this is what really matters for today, and that is this self-defense. And it's interesting because I actually have another poster I'll show you in a little bit, trying to figure out how to make self-defense make sense to you, because it's sort of like disproving a negative. The state carries a burden, without question, of proving to you beyond a reasonable doubt that George Zimmerman did not properly act in self-defense. And if I misspeak, let Mr. Guy fix it. George Zimmerman is not guilty if you have just a reasonable doubt that he acted in self-defense. This is where I'm going, just so you know. We're going to spend about 10 minutes with me bringing you all the way up to here, proving to you beyond a reasonable doubt that he acted in self-defense. But I don't need to. The state needs to convince you all the way down here. Is self-defense likely? It's a reasonable doubt as to self-defense. Is self-defense suspected? Well, you have a reasonable doubt as to self-defense, not guilty. May not be self-defense, you're not quite sure. Not guilty. Unlikely self-defense, but it might be. You've got a doubt as to whether or not it's self-defense, not guilty. You know, it's less than likely is it self-defense. This was a 50-50. I wouldn't vote self-defense. This was a civil trial. Highly unlikely that it's self-defense, but I have a reasonable doubt as to whether or not it's self-defense. Not guilty. The state has proven to me, to you, beyond and to the exclusion of every reasonable doubt, that he acted in self-defense properly. I have no doubt, a reasonable doubt, that the state has convinced me he didn't act in self-defense the way he should have. Then he's guilty. And only then is he guilty. So, let's talk about my burden to prove to you beyond a reasonable doubt of his innocence. At the risk of confusing you, I'm going to request that you not allow me to confuse you as to the standards. But I want to show you what the evidence has shown concerning my client's absolute, beyond question, beyond a reasonable doubt, innocence. Where shall we start? Well, let's start before the beginning. Let's start with what the state wants you to focus on, that he was a cop wannabe. And he did want to be a cop. He also wanted to be a prosecutor, and he wanted to be a lawyer, and he wanted to continue his education, and he wanted to help out his community, and he wanted to help out people like Miss Bertolon by giving her a lock, and he wanted to be involved. You even heard that he mentored some kids from Officer Serino. He wanted to be involved. And yes, he wanted to be a cop. He even applied for it. I think what you also heard, I would argue to you, is you heard from the other officers who actually wanted to be cops and then became cops, that it's a fairly noble profession. It is a profession that its moniker is protect and serve. I think it's apparent that George is willing to serve. I think it is. All the evidence that you do have supports that. And actually, it doesn't support any of the contention that he wasn't. It also supports the contention that he's willing to protect. And I think that's readily apparent from all of the evidence. Keep in mind, the state had the opportunity, no, I take that back. They had the obligation to show you any piece of evidence that they thought was appropriate, that they could, to show you that his actions were inappropriate. And what did they decide to bring to you? 2 professors. A couple more, we'll talk about those. 2 professors who say, oh yeah, I taught him. I don't know if you read that book, and but I definitely, it was in the class, it was an online class, and we spoke about it. And he told me he wanted to be a prosecutor. And I think he said, he made after this, he seemed to be easygoing, or I liked him, or something like that, whatever that, the guy who was first on Skype and then on cell phone. Then the other professor they brought in to say to you, oh yeah, I taught him this. And we talked about self-defense. And yeah, we talked about it, and he knew about it. So yeah, that's what they want you to focus on, because this cop wannabe knew what self-defense is. So they have that. What else did they decide to bring you about his background? That he did make it as a cop one time. I think you know that he works as a fraud guy at a mortgage company. And what else did they show you to buttress their position that George Zimmerman is before you acting with ill will, spite, hatred, and just hated Trayvon Martin that night? What other evidence? I'm not being sarcastic, I might be forgetting some as far as his background. The 5 phone calls to non-emergency. You heard them, you have them in. You know something, you also have the 6th one, because I put that in. Because for whatever reason, the state didn't present to you call number 6. It doesn't support their case, I guess, because it's just him calling, being concerned about the fact that a bunch of kids are playing outside and cars are swinging by them. He just not really complaining, just want to make sure there's some 4-year-olds out there, some 6-year-olds out there. Listen to that, because you haven't heard it. I didn't play it to you, but it's in evidence. I think it just sort of rounds out a little bit. Instead of having 5 or 6, you have 6 of 6, and now you sort of know what the state didn't show you. They don't have to show you good stuff about George Zimmerman. But they did say they were going to seek justice. Let's not forget that. They told you in the beginning of this case that they were going to seek justice. So you have this 5 phone calls and now a 6th one. I also put into evidence, but didn't shove in front of you yet, but it's here. It's this whole pile of reports, police reports, of what other things happened in the past year at Retreat View area. They're there. I could have brought in Ms. Rumpf, like the state did, or other people, but we just agreed they would go into evidence, and you have those. And they will show you a lot of alarm calls, a lot of burglaries, the home invasion that Ms. Bertolon suffered through. And they will show you, I think, if you look at this, that in that community, there was a rash of people burglarizing homes. And you know what else it's going to show you? It's going to show you that a lot of the people who were arrested for it, the only people who were found and arrested were young black males. We're going to talk about race in a little bit too. But they're going to show you. And the reason why I mention that now is we talked about assumptions and what you sort of bring into your world when you come into our world. Because certainly you heard on the non-emergency call how George acted when he saw Trayvon Martin. And we'll get to that in due time. So what else do they have about George Zimmerman and his past that they bring to you? I think that's about it. So I would suggest that that's on the way towards absolute innocence. Why? Listen to the calls. Anger, frustration, hatred, ill will, spite. Get out here and get these guys. I hate these young black males. Or whatever the absurdity is that they want you to get from that. Listen to the calls. Do not allow them to give their words to your ears rather than George's. Listen to what he said. Listen to the cadence of his voice. Listen to what he said. Read those reports. Look at those people who lived through, not many of them were home like Ms. Bertolon, but what they came home to, and then wonder whether or not a frustration in Mrs. Zimmerman's voice is inappropriate or appropriate. So that's his past. So what have they shown you as to how he acted now? And how I convince you of his absolute innocence? Let's go to the 26th. On his way to Target. Undisputed. Does it, I think someone said, Mark Osterman, he does it every Sunday. Just his regimen. Makes his 5 sandwiches in the little plastic containers. That's what he does. So, by the way, as to absolute innocence, tell me the witnesses who said to you that George Zimmerman patrolled that neighborhood. We're going to go over the witnesses. I have a whole PowerPoint presentation. I promised it won't take as long as it took me to make it, to present it to you. But there is not a witness in there. Not one. State's case. Not one who will say to you, remember George Zimmerman? Yeah, the guy wandering around the neighborhood, looking around, talking about, hey, bring in your garbage cans or some absurdity like that. Not one witness to suggest that the guy who they want you to believe is the neighborhood watch, cop wannabe, crazy. Not one. They may want you to assume that, it would seem. And you would have to assume it because you certainly can't find it. So you'll have to assume that this neighborhood watch guy was just some crazy guy walking the neighborhood looking for people to harass. Except that's an assumption without any basis in fact whatsoever. Not one. Another note from Mr. Guy. If I'm wrong about that, let him tell you. Let's show the point where Mrs. Jones said, well, I was a little bit scared about him. Didn't like the fact that he kept circling in my house. Not one. What do they really have? They have Miss Bertolon. He called Miss Bertolon and said, came over. I heard what happened. Really sorry. We're just starting this neighborhood watch. When he drove all, told us that there's real problems with these sliding glass doors. Here's the lock. And you know what? My wife's home. She works. She's a nursing student or something. She's around. She's home if you need to stop by. Innocence. Pure, unadulterated innocence. I would suggest that that shows to you. Certainly as far as second-degree murder or anything like it. So, in my quest to prove that he's innocent beyond a reasonable doubt. He is on his way to Target, and he sees somebody that was suspicious. So does he jump out of his car, unholster his weapon, track him down, shoot him in cold blood? No. He does what he was told to do. He calls non-emergency. Not a big deal, not an emergency. But he did tell you, of course, in the statements at least, and you know because it's in those reports, that at that very same house, maybe coincidentally Trayvon Martin, was burglarized a few weeks before with a window open and a door unlocked in the back. Is it inappropriate for that to become a concern to somebody who's concerned about his neighbors? I left my house last week. There was a white truck down the street. I looked at it. I usually took a left out of my driveway. I took a right just because I wanted to see who it was. There was a pool sign on the side of it, and I kept going. Okay. Well, in this case, he does what? He calls non-emergency, and he says, knowing full well, given the benefit of some of the history the state wants you to use to convict him, that he knows it was being recorded. They say it in the beginning, and he's done it before. So he says on the call what he says. I'm not going to play it for you again. You've heard it more times than most people. And he called him an asshole. Actually, he didn't call him an asshole. He said these assholes, but he's probably in his mind in that group of people who in the past have gotten away. So he called, and he spoke to the dispatch, and he went through it. So, looking at the question of whether or not my client is completely innocent, provably innocent, what did he do? Stayed on the phone, cursed. Well, yeah, definitely cursed. And he cursed towards those people, maybe including Trayvon Martin, by the way, at least to him, maybe, because he did match the description, unfortunately, and that's just maybe happenstance. We'll talk more about that, too. So, calls it in and stays on the phone like you're supposed to. Does what you're supposed to. Describe him. Think he's black after being asked. Black, white, Hispanic. So, how do we move from I'm looking at a suspicious guy that I'm not sure, it's raining out, he's obviously not coming in the main entrances, maybe that's an issue. When you look at those reports, you'll see that there are ingress and egress points, at least there used to be, where some people do come in to do bad things. And he talks to the non-emergency. And he basically stays on the phone all the way through. So, where's the guilt? No, that's not my burden. Where's the non-guilt? Well, never screams. Mr. Guy screamed. Delarianda screamed. George Zimmerman didn't scream on that call. Of course, then to cover up his non-scream, at one point, Mr. Delarianda suggests to you that, no cell phone, that what he did was under his breath. As what he wants you to assume within that context is he said it under his breath because he wanted to say it, but he didn't want non-emergency call to hear it. And then he wants you to assume that what that means is guilt. Seriously? Seriously? Here's a way you do that. Effing punks. It's just the fact that he was willing to say it on a recorded call to law enforcement is evidence of non-guilt. It is evidence that he wasn't saying it in a way laced with ill will, spite, hatred, or anything else like that. So, call continues. And now we have the call. Now we have our first very large graphic. This is what happens when you get carried away with graphics. They get 10 feet long. What this is a graphic representation of the significance of the phone call that started at 7:09:34 that night. You will have this back with you so you can sort of go through it. It doesn't include every word that was said back and forth because it would have been 20 feet long, but it does have, I would argue to you or submit to you, it has all of these significant words. So let's sort of go through it. You have the tape, I could play it for you, but you've heard it many, many times. It starts, dispatcher, Sanford PD, can I help you? And George says, some suspicious guy, whatever. Then he says, note down here that Trayvon Martin is on the phone with Rachel Gentile. That's sort of significant when we get down here, but we'll talk about it as we come down the line. Now he's just staring at me. 7:10:21, so we're looking at it about a little bit less than a minute later, and he's just doing it. Yes, he's near the clubhouse right now. Yeah, he's coming towards me. There was some confusion, I think, maybe it's been cleared up, that George Zimmerman pulled into the clubhouse, backed down and went down the street, Twin Trees, and then parked. But this is when he was sitting at the clubhouse, it would seem. It seems to be uncontroverted. And this is on here because the suggestion is that this cop wannabe was just so frustrated, so angry, so full of ill will and hatred, that finally he cracked. Finally he broke. And I'm going to ask when you go back to figure out where he broke. But maybe this is a spot. Maybe it was just after the dispatch said, okay, just let me know if he does anything else, okay? Now they want you to really focus. We're going to, in a moment, we'll get there. They want you to really focus on the idea that Sean Nofke said, we don't need you to do that, and that was a command of law enforcement, and somehow he violated it. We'll get to that. But they don't want you to focus on the fact that this same law enforcement officer says, let me know if he does anything else. So, here's a thought. Let me know if I do anything else. Have I done anything else? Please get an officer over here, is his response. Evidencing the ill will and hatred necessary that you just want to go kill somebody because you hate them. Please, please get an officer over here. Twice. Let me know if he does anything else. Twice. Okay, well, it makes sense. That's, I think, probably what they're supposed to ask. And then the person hearing that says, okay, or does something to let him know if he does anything else. These assholes, they always get away. Use his words, listen to the tape. You know, I have a tape of Mr. Del Rionda and John Guy saying it their way, and I was going to play it for you. But it's so irrelevant. It's not evidence, obviously. And what really counts is the way Mr. Zimmerman said it. So listen to the tape. And, you know, see if in that you walk away, just at this point, right here, you walk away with ill will, spite, hatred, and just this animus towards Trayvon Martin. Shit, he's running. Okay? And the next second, which way is he running? So, I'm not going to do it again, but if I would ask you which way I was walking, and I walked out the door, and came back, what information would you have? That I walked out the door. Why? Because you probably watched me do it. Because I just asked you, which way am I walking? So, ill will, spite, and hatred, or innocence? I would suggest that at this point, this is a conversation. Don't forget, when they're doing this conversation, they had no idea we were going to be here today. They had no idea that we would have a 10-foot graphic of every sentence that they talked about. They were just talking. What's he doing? Let me know. Where is he now? Which way is he running? And he gets out of his car. Now, at this point, I think the state, maybe this is another break point. Maybe this is a break point where George said, oh, what's the network movie? I have it, I just can't take it anymore, something like that. Maybe that's when it happened. Well, let's see. No, maybe not. Gets out of the car, says, down towards the other end of the entrance of the neighborhood. Listen to that, see if there's this crescendo of hatred in his voice. Which entrance? The back entrance. And he says, we just got so used to using this in front of regular people. And just, you know what he said. I'm not going to use the words anymore, not as oversensitivity to you or to pander to you, but we use the words enough in this courthouse so far. And then he says, are you following him? What does George say in his anger and hatred and plan to track down and kill this unknown person? Unknown is important because ill will and hatred and spite, it's difficult, don't you think, to really gain that for somebody who you don't even know? How do you actually get to the level necessary for second-degree murder when you don't know the person? But anyway, ill will, spite, and hatred. Has it shown right here? We don't need you to do that. Is that when he says, screw you? I'm sick and tired, I'm not going to take it anymore? No. What does he say? Okay. And we're going to talk about wind noise. Matter of fact, I put into evidence for you to look at. One the state put in, I put in the weather reports for that day. Because strange as it seems, a year and a half later, we want to make sure that you know that it was raining out, even though a bunch of people talked about it. But we also want you to know that the wind was up that night. You'll see that at the time of this event, the wind was about 6.8 to 7.2 miles an hour. I put it in the 27th because you also hear wind during the recreation video. In the phone, you sort of hear the wind. Because the question is, was George Zimmerman tracking? Was he running after him? We know he was following him because he said it. The question is, was he tracking him? And the wind noise, the running noise, make up the... I will ask you, as the state did, you guys get to decide that. But what I really want you to focus on is where this ill will, spite, and hatred comes in. So does it come in here? And then he says, what's your name? George. And he says he ran. Did he say he's ran and I'm running? Is there any evidence to suggest... Let me ask you a second. Is there any piece of evidence that you have in this case that supports the contention that George Zimmerman ran anywhere, or that he ran after Trayvon Martin after he said, okay? I have another challenge for the state. Let him tell you about it. Let him show you in the record of this case that they have evidence that he ran after Trayvon Martin, walked after him after he said, okay. Because if it's there, I missed it. Presumption, assumption, connecting the dots, sure. But you've agreed not to do that. And don't let them let you do that. And then tells him where the address is, apartment number, it's a home. Now at this point, I think right around here is when he says, well, you still want to have an officer? Oh, yeah. Yes, I think he says. Okay. Where do you want me to meet him? Clubhouse they talked about, at the truck they talked about, and then I guess in the state's presentation to you, they have said, and maybe will say again, that at that point, that's the ill will, spite, and hatred. I guess, because at that point he says, no. No, I'm going to go track him down and shoot him or something. So just have him call me. Not forget, 16 months ago, regular phone call for Sean Nofke, sort of a regular phone call for George Zimmerman. And I'll tell you where I am. Big deal made about the recreation video and the numbers right behind him and the numbers not on the back of the door. By the way, one other point on that. Which witness, and this is going to sound as though I'm being a little bit sneaky, so let me premise it with that. Which witness told you that Miss Lauer's lights were on that night? So the numbers that they want you to believe that Mrs. Zimmerman walked by and said, I just want to go after him. Just so we're clear, the witness that showed you that Miss Lauer was here, and the state asked the question of her, just so we're clear, because we really want to prove that he was doing this intentionally and trying to say something that we can catch him on later, please tell the jury that your lights were on that night. They never asked him that. They just didn't. Because they want you to presume and assume and connect the dots and do whatever. Now, is that sort of sneaky? No, sorry. This is their burden. They have to take away reasonable doubt. They have to look at this case and say to you, ladies and gentlemen of this jury, hi, we're the state. We have proved this case beyond and to the exclusion of every reasonable doubt because we have connected every dot that forms a line that leads to nothing but conviction. And they just didn't. So, now what happens? Along my path towards beyond a reasonable doubt innocence, what evidence do we have? I would contend to you that though there was a minute in this tape, or after this tape, he hangs up, 7:13:44. We know Miss Lauer's call starts at 7:16:11. There's some time in there. We know that Miss Lauer heard it about 15 to 20 seconds before she decided to make the call. She testified that it took about 25, maybe, I think she said 25 seconds to get the phone, dial it, try Jeremy's phone first. That didn't work. Try hers, connect, 30 seconds. Back it up another 30 seconds as to what George Zimmerman was doing. Now, we know that he said, at a time that he didn't know that he had to protect his story, that he said that he's still gone all the way to a Treat View Circle, sort of makes sense, I would submit, and that he was coming back with that little baby flashlight, because the other one, the impact weapon that was pointed out by the state, that was not used as an impact weapon, this little flashlight on his keychain that he had. So he had this, and it was on. You'll see the pictures of, you know now, I think, the pictures of the darkness that night. One is stunning in that you sort of see, here's the field of flash, and beyond it is almost like this black wall. It was that dark. So yeah, he had his flashlight with him, and he had it on. And if that's evidence of tracking Mr. Zimmerman, let the state prove that to you. So, we don't know. Evidence seems to support that George is heading back towards his car, and they don't have one shred of evidence to suggest otherwise. And if they had it, I presume that they would have presented it. So where is it? What evidence do we have that it happened at the T intersection? Well, we have the flashlight. Probably not a bad idea to start there. Because somehow that flashlight got dropped right there. But not just George Zimmerman's story about that is there. We have Jenna Lauer, who said, I heard the noise and it was out that way, sort of towards the T intersection. Did she look? No. Did she hear? Yes. Is she close? Probably. And we have Miss Manalo, opposite side, saying it was off to the right, consistent with the T intersection. We have Miss Sudiker, who, though we had some questions about what she saw and how she saw it, nonetheless, she said it started sort of outside of her window. So we know that the altercation certainly seems to have started exactly where George Zimmerman said it started. And that somehow it got dragged down to the area where Trayvon Martin was actually shot. I'm going to show you what Mr. Del Rionda mentioned. It's an animation. It's not evidence. It doesn't go back there with you. It's just an overview of some of the evidence and how it may look in the context of it. So if it works, we're going to spend a moment to just look at it. It only runs about a minute and a half. It does have the 911 call on it because it's used to sort of set the scene a little bit as far as timing. And then I'm going to come back and sort of explain some of why what is in there. Only if it works, though. What's the chance of that? This getting messed up if we disconnect one item and put on another. You don't know, or it shouldn't. Great. Charm?
See me?
Okay, a couple of assumptions and a couple of problems with this before we look at it. You see where they started. I have Mr. Martin sort of approaching, coming down the sidewalk. There's questions or conflicts about that. Was it bushes? Was it sidewalk? Was it behind me? And of course, you can see it. It's lit. If it was real weather and lighting conditions, we would be looking at a black screen. So some artificiality that I've had to include in the animation to show you is just things like that. But what I want to look at is how the event may have happened at the T intersection and how things sort of progress from there and how that comports with some of the evidence. Of course. Or not. T intersection. The first, there's the shot to the nose, we contend. Number one right there is where the flashlight is found, George's small flashlight and his key. I didn't have any movement except to get them to the spot of the eventual shooting because we don't really know what happened, although George Zimmerman did say that he tried to push him off and tried to push him away. I think in the video there were movements like this that we saw. Whatever, somehow they got those 25 or 30 feet to the area where we know things happened because this perspective right here, you see that column on the left-hand side, this is John Good's patio, where he was actually standing and he came out. The items match, just so you know, the items match precisely the areas where all the evidence was found, and the numbers match the graphs that are already in evidence before you. So you'll see 8, 1, 2, 3, all of those match up because they came from the same data. What I've done on this is I've now begun the 911 call because it's pretty close to time synced to John Good's event because you remember he testified, he was looking at what he saw, 8 to 10 seconds, he went inside, decided to make the phone call to 911. We use that as about 20 seconds or so, an assumption, I agree, because Jenna Lauer had testified it took her about 20, 25 seconds to make the decision and dial 911. So we sort of had to figure out exactly the timeline as best we can.
Maybe both, I'm not sure. There's just someone screaming outside.
Okay, what's the address that they're near?
Address was taken out.
Is this in Twin Lakes House?
Now this is when, according to Mr. Good's testimony, he came out and saw what he saw. What we've done is take away the animation and just use 3 different figures or positions because this is what he said he saw. He said when he came out, he saw them sort of straddled one on top of the other. And then he saw them move towards the sort of parallel. We were having confusion with horizontal, vertical, parallel, and perpendicular trial, but I think the indication was they were parallel and maybe on the concrete. So that's going to come up next.
Twin Lakes Homes in Sanford?
Yes.
Okay. And is it a male or female?
The second position where he said this is the mounted position or where the ground and pound was occurring. This is where he said it happened closer up to the cement. Again, consistent with what Mr. Zimmerman was saying when he was talking to the officers. Or you decide if it's consistent or not.
It sounds like a male.
And you don't know why?
I don't know why. I think they're yelling help, but I don't know. Just send someone quick. Say, ah.
Does he look...
The third position is when John Good, as he was leaving, said that they sort of come down away a little bit. Mr. Zimmerman said that he was sort of trying to shimmy or to get off specifically being on the concrete. And this is also put in there, and again, there are some assumptions in this animation, because the next position that you're going to see is the position just after the shot. This is the position where we contend the shot happened.
Does he look hurt? Do you think he was dead?
I can't see him. I don't want to go out there. I don't know what's going on. So
The angle of those two people, obviously one sort of over the other. You remember Dr. DeMaio's testimony and other people's testimony, even Mr. Root, I think, testified that because of the way the clothing is, that if leaning over, it was consistent with the gunshot, that being contact, not pressed to the chest, but contact with the clothing, and then about 2 to 4 inches away from the chest.
they're sending him.
So you think he's yelling help?
Yes.
All right, what is your...
Now you see we have George Zimmerman on top with the red. His testimony was shot him, that Trayvon Martin fell sort of off and to the left. You'll look at the scene photographs where you see Trayvon Martin's feet are sort of in, someone called it a bicycling position. They just, I would argue, consistent with having been shot and fell off to the left, his side, and then fell onto his stomach. George Zimmerman then got on top, as he testified to at least to move out the hands.
There's gunshots.
You just heard gunshots?
Yes.
How many?
There's one. Jimmy, get down.
Now, this right here, by the way, what you're seeing is what it's called a 50 millimeter perspective. The human eye sees things at about 49.5. Well, I can't tell you that because I don't know if that's an evidence. Anyway, it's at a 50 millimeter perspective, similar to what people see when they look, which is what John Good had, and which is what this has right here, because this is Selma Moore's perspective. This is the column that she sort of said she looked out and around, and the timing is appropriate because we had it about 6, 7, 8 seconds from the time of the shot, which is when you remember when Miss Moore did her sort of walk around in the courtroom. She said, and if you timed it, it was about 8 seconds thereabouts. And she took, hear the shot, react to the shot, walk around, come around, go outside, shimmy through the door, look out, and that's what she saw. So she would have seen, at least according to George Zimmerman's story, she would have seen George on top, spreading out the hands. And she said she saw the foot move. She said that at that point, George Zimmerman sort of got up, looked around. You remember her testimony, and we'll talk about that in a minute as well. So this is what she saw, or at least her perspective. And then
No, come here.
this is now
Is he no
the
longer?
rest of the 911 call.
No one, I don't know.
You've heard it. It's not particularly
Jeremy,
significant
get
to the
in here
event
now.
because
Jeremy, get.
nobody said that they saw anything of relevance beyond that from this one. Thank you, Your Honor. Let's hook this back together. See if it works. The animation, of course, is just that. It's somewhat made up. I mean, it wasn't that night. It wasn't a videotape, although George certainly hoped that there was. George Zimmerman, sorry, hoped that there was. But it does give an idea, a perspective that at least is consistent with the evidence that was presented before you in the case, because it does show the probability, if not the exact certainty, that this event started at the T intersection or thereabouts, and it started with a shot to the face. Trayvon Martin against George Zimmerman. And then it traveled down those 30 feet or so, however they ended up there. We know that when they ended up there, that the only one who was injured at all, except for the gunshot, was George Zimmerman. And that the only other injury that Trayvon Martin had on him was what seemed to be a fight injury from a couple of scrapes of the knuckle. So, again, in my quest, my dangerous quest to prove my client's innocence beyond a reasonable doubt, now we get really into what happened. Because you can argue, and the state will, all you want, that George wanted to be a cop. And George's calls to law enforcement in the past just had some seething anger buildup. But don't assume it. Prove it, believe it. Don't prove it, it just doesn't exist. And don't connect those dots if they're not been connected to you beyond a reasonable doubt by the state. So now let's look at what really happened that night. And let's see, the graph is done. So what were these people doing just before? Spend a moment on that to start talking about my client's absolute innocence. There's about a minute and a half, something like that, after George's call, that he was doing something. Whether or not he was wandering up to Retreat View Circle to get an address, whether or not he had that flashlight on looking around a little bit, whether, as he said to the law enforcement officer, I do want to try and figure out where he is. I do want to at least keep him a visual on him. Whatever. That was about a minute and a half. It's really interesting as well about the phone calls is what Trayvon Martin was doing. because we haven't spent a lot of time on that yet, but the evidence is sort of compelling as to what he might have been doing. We know that he was on the phone with Rachel Gentile, and we know that that ended, we have the times, it's all in, at a precise time, and it kicked back in. And that she said he was running, which actually coincides pretty straightforward with when George said he was running. Some consistency there. So, Trayvon Martin was running, and he was running at about somewhere nearby 7:11:47. Keep that number in mind for a minute. 7:11:47. Because the altercation, according to Miss Lauer's phone call, if you sort of look at when her phone call started, back it up to when she heard what she heard, she called at 7:16:11. Give her 30 seconds or so to have started. Right? Somewhere around there? We're going to take a break for a couple minutes because I didn't realize I've already been talking for an hour and 20 minutes. So we're going to take a break. But before we take a break, here's what I'm going to do. We're going to sit tight, and we're not going to talk. And I'll tell you when we'll talk again, okay? So try not to do much, starting now. That's how long Trayvon Martin had to run. About 4 minutes. When he said he was running, that's how long he had. So, let's talk about who was doing what and when. Chad, first witness who we talked to, said he could probably throw a football from his backyard to the T intersection. We actually don't have evidence from the state as to how far that was, but I gave you a little bit of an insight. I'm not sure who plays football around here, but nonetheless, this is where he was staying. This is where George's car was parked. This is the T intersection. And Chad could throw a football. He actually probably can't throw a football that far because it's a little bit further than that. But there are some good football players who probably could. He had 4 minutes. And he told Rachel Gentile that he was running. We sort of know, for the most part, what George was doing there. Miss it. But since this is the state's case and not mine, did they show you, tell you, explain to you, give you any insight whatsoever on what Trayvon Martin was doing 4 minutes before that fight started at the T intersection? Do you have a doubt as to what happened and what Trayvon Martin was doing and what he must have been thinking for 4 minutes? Maybe time for a break. Am I on?
Yes, you may. Ladies and gentlemen, if you'll please put your notepads face down on the chair, follow Deputy Jarvis down into the jury room. We will take a 15-minute recess. Please be seated. Court will be in recess for 15 minutes. Please be seated. We're back on the record. Are you ready to have the jury brought back in?
Yes, Your Honor, thank you.
State ready? Okay, let's bring the jury back in.
Jury is present, Your Honor.
Please be seated. Mr. O'Mara, you may continue.
Thank you, Your Honor. 4 minutes. That felt like a long time to you before we took the break, that we sat here and did nothing for 4 minutes? You get to think what Trayvon Martin was doing. You get to try and figure out why, when he said, George said, at 7:11:40, he's running. (7:15:43), when Rachel Gentile tells you the phone call ended because of a bump. 4 minutes. To do what? To walk home? To run home? 4-minute mile was broken when I was like 12 by somebody. And I think he was in his teens. Don't know if he played football. Don't know if he was a defensive guy on a football team, but I do know that you can run a mile in about 4 minutes if you're in decent shape. So we know that with the opportunity to go home, that he did not. We know that because of the football throwaway. So let's talk about factual innocence of my client, then I'm going to finally leave this behind. I want to talk about factual innocence. Somebody decided that they were angry. Somebody decided they were ticked off. Maybe somebody decided that they just had ill will, spite, or hatred. For whatever reason, somebody did decide that it wasn't over with the running. Because it wasn't, after all. It had only just begun, right? Isn't that really what happened here? It wasn't some cop wannabe. It wasn't some, I've learned about how to talk about self-defense, and oh my God, he forgot to say I have to stand your ground on Hannity. Let's convict him. He didn't tell Hannity, I've heard about stand your ground. The person who decided that this is going to continue, that it was going to become a violent event, was the guy who didn't go home when he had the chance to. It was the guy who decided to lie in wait, I guess, plan his move, it seems, decide what he was going to do, and when. The state told you that he had no decisions. They dared to tell you that Trayvon Martin had no decisions, that my client planned this? Really? 4 minutes. 4 minutes of planning. And they want you to ignore it. I guess, because if you don't ignore that, factual and undeniable innocence. Because with those 4 minutes, now let's use your common sense. Now let's decide what probably happened that night. Because we know the result. Now let's try and figure out the why. George Zimmerman probably heading back to his car, looking with his little baby flashlight for Trayvon Martin a little bit. Maybe. Maybe. Not proven, but maybe. Trayvon Martin, 4 minutes, doing something. And we don't know. We really don't. We know he's on the phone. We know he's talking. We know what Rachel Gentile said he was saying about whatever he called him. And I don't care that he called it some stupid name. He's 17 years old. They get to talk stupidly if they want. I'm okay with that. And I'm okay with Rachel Gentile being 16 or 18 or whatever. Who cares? She didn't want to be involved in this case. But the reality of what happened is very straightforward. And it proves absolute innocence. Because for 4 minutes, Trayvon Martin to do something that led to his confronting George Zimmerman. That, I would suggest, not because George Zimmerman said it. Throw out everything George Zimmerman said. Just forget it for a minute. Just, it didn't exist. He did what I probably would have told him to do if he called me on the 26th that night. Shut up. And don't say a word to law enforcement. I'll see you there in half an hour. I would have thrown on a pair of jeans, said goodbye to my wife, and run out the door to go see a potential new client. And I would have said, oh, no, no, no. You are not talking to law enforcement. Particularly not looking like you look. And particularly not having just shot somebody and I don't know anything about it, so hush up. And now tell me. So let's just make believe that happened. Let's just take all of his self-serving, cop wannabe created statements and throw them out. What do we have? You've seen the picture a lot. You're going to see it again. What we do have, and thank God for Jenna Lauer, because when Mike Wagner went to her, can you pick out the guy, the potential shooter? She said, no. Go get me a picture. And I'll look at the picture. But somebody who shot somebody, I don't want to go say, I know who that is. So we have this. Interestingly, and thankfully we have this, because if we didn't have this, we would only have the cleaned up photo. The one that doesn't show the significant injury, you know what I'm talking about. The one that says, you know, the nose is sort of back in shape. I don't know who put the nose back in shape. I don't know how it happened. But I do know it did look like that right afterwards. So if Mr. Zimmerman just created all of his statements and we throw them out, we start with this. Because this is undeniable. This is significant injury. And then we have the back of his head, and you know all about that already. And what else do we have? We have 40 seconds of screaming. When I first got this case, I thought it was going to come and go in 20 minutes. Because when I found out that there was a 911 call with somebody screaming on it, it was game over. Figure out who it is, and then we're done. Because the alternatives are Trayvon Martin screaming, and my guy is some horrible, extended, torturing, then eventual murderer for 45 seconds. Something, if it was Trayvon Martin, something strange was happening for it to be him. Some bizarre 45-second event where he would scream for help, yet still be able to batter George Zimmerman, but they'll have their theory. I guess they're going to tell it to you in the final closing. Or it was George Zimmerman. And if I could get this to whoever, FBI, let's say, do a little comparison, and we're done. You heard from Dr. Nakasone, unfortunately, it couldn't be done. So now we don't know. Now, as Mr. Delariano suggested, now you do get to decide, I guess, or not, of course, or not. You just simply get to decide that you can't decide. And then who gets the benefit of that? Mr. Zimmerman. So let's not forget about that standard as I'm wandering you down my little make-believe path of factual innocence. Then what else do we have? We have his initial immediate statement to Mr. Manalo. And the way he looked. Samamora looked like he was beat up. Oh no, he looked like he was bending over. Manalo looked like he was beat up, and he just looked strange. And then, of course, as Mr. Delariano said, oh, just tell her I killed the guy. You see, not what he said at all. I think what he said, and use your own memories, was that when Mr. Manalo took the phone because he had to drop it, because Tim Smith was doing what he does as a trained law enforcement officer and said, hands out, on top of your head, behind your back, where's the gun? Drops the phone, Manalo gets it, and says, words to the effect, your husband's been involved in the shooting. And what's the response from George Zimmerman? Tell her I shot somebody. I guess what he should have said, and what he was thinking through, and what he wasn't thinking through, whatever he was going through, whatever the injuries were, whatever, as Manalo said, he just looked like he was out of breath. He should have said, well, that may sound insensitive a year and a half from now. I should have said that I had to shoot somebody. I don't know what he should have said. He told his wife he wasn't the one shot. Unusual, inappropriate. Somebody calls up and says, honey, I was just involved in a car accident. What's your first response? Are you okay? You don't even say, is the other person okay? Right? It's just not natural. You okay? You ever say, oh, well, is the car okay? No. You do what you know. You do what you deal with on a daily basis. Don't tell I'm involved in a shooting. Tell I shot somebody. So, we have that evidence. We have Smith, who says right away he told him he was screaming for help twice. Then we go forward, we have the medical personnel. Screaming for help is fun, because here, now the state wants you to say, this mastermind criminal, this guilty beyond a reasonable doubt second-degree murderer knew at that precise moment that he darn well better say that he was the one screaming. Because after all, he had killed the guy who was screaming, in the state's theory, right? So he knew he took care of that problem. Real problem with that theory, unless the mastermind knew, when Singleton mentioned in an interview that Trayvon Martin had passed, George was affected. I guess it could be part of the mastermind criminal behavior that he learned in community college. I guess it could have been, but let me tell you, if you have a doubt as to whether or not that's true, you need to tell the state, don't ever come back before us again with a case like this. Don't ever do this to us. Because what we really have is what I said a while ago. We have factual innocence. You could go back there right now, look at the facts of this case, and say, we're going to flip the standard upside down. We're not going to allow Mr. O'Mara to get an acquittal for his client simply because the state hasn't proven their case beyond a reasonable doubt. We're only going to allow Mr. O'Mara to get his acquittal if he proves to us beyond a reasonable doubt that his client is innocent. And you could, because he is. Because he acted in self-defense. Not the standard, of course. So let's talk about the standard to see how far afield from that very standard that the state is supposed to take on what they actually have accomplished. I'm going to first spend a moment on the witnesses. Real quick, I'm going to get through it as quickly as I can. There's like 50 of them. And I could have the lights dim just a bit, Your Honor. And hopefully this will work. Chad Joseph. I'm just going to go through them. Didn't have much to say. You could throw it about a football field, but that's it. As you know him to be the sort of stepson of Trayvon Martin. Andrew Gaw, 5'10". That's important, and we're going to get to that in a second. You saw him stand next to me, and I did that on purpose to show you that I'm a few inches bigger than he is. And he was 5'10", in the shoes he had on that day. All he really said, didn't know much about that event. Sean Nofke, what did he say? Interestingly, because the first time that somebody was talking to George was this guy. And what did he say? No anger, no animosity, no hatred, no anything in George's voice, quite matter of fact. A person who's trained, by the way, to deal with stressful situations and to understand and to dynamically interact with people on the other line, because sometimes these things turn serious quickly. And what did he say? Nope. He even accepted the reality that George may have misunderstood when he said, which way is he running, that George Zimmerman may have thought, I should go find out. He acknowledged. Maybe it was imprecise. Whatever. Next witness, Ramona Rumpf. She brought in the records custodian for the 5 calls. She also, you'll see the affidavit, I think signed by her, of the 6th call. Listen to it if you want. Nothing to do with burglary. It's just George Zimmerman being George Zimmerman. Wendy Dorival, interesting witness. The lady who set up Neighborhood Watch a few months before because, as she said, they looked at the crime stats for that neighborhood and it was being assaulted by burglaries. And something needed to be done. So she went in and she did something. And she told us, who might be suspicious from her experience and training. Remember, this is her love, not her job. She does this as a volunteer because she likes the idea of people being involved in the neighborhood and helping keep crime out of your own home and out of your neighborhood. Someone you don't know could be a reason for suspicion. A person walking in the areas they don't belong. Maybe. Someone walking in the rain without purpose. I don't want to just have you acquit my client because I can show you that Trayvon Martin did something bad, but I'm also not going to allow you or the state to ignore the realities of what actually happened that night. And describe Mrs. Zimmerman, to her knowledge, as meek. The other interesting thing about this cop wannabe, they have this Citizens on Patrol program where you get a uniform, you get a car, little yellow lights on it. They can't be blue lights like we have for true law enforcement, but you get little yellow lights and you get to drive around and act like a cop. And he said to that opportunity to be a cop wannabe in a cop uniform and a cop car with cop lights and probably a little cop computer in his car, or at least a cop clipboard, no. Thanks, but no. I got what I'm doing. I'm working, I'm going to school, got my wife. I don't want your cop car. I don't want your lights. And I don't need your uniform. But this is the guy that the state is telling you, get ill will and hatred out of his cop wannabeism? Really? Seriously. Have they proven that to you? Have they come even close? Except for speculation? How many times did you hear an objection on the stand to speculation? Well, because we're not allowed to do that in court. Can't be a witness up there and say, what do you think? Maybe? Because it's not evidence. And that's why. It's not evidence for you. Because then you would go back there and go, well, John Doe speculated, and the judge allowed it. I guess we can speculate. Absolutely not. Absolutely not. Donald O'Brien. HOA guy, parking committees, George helped him with parking. Cop wannabe? I don't know. Doesn't seem, if he doesn't want the cop car. Involved, citizen, sure. Any complaints, by the way, that the state brought to you about him just towing cars away, or ticketing people, knocking on, get your car off that yellow? Anything like that to foster their argument to you that he was doing something wrong. Because remember, we've agreed not to assume. So where's the evidence? And they talked about the 17-year-old burglar getting caught, and thank God the stucco guy caught him. And now Mr. De Leon just says to you that George Zimmerman was frustrated. Ooh, I wanted that one. Damn, darn. The stucco guy got him instead. Not going to happen again. Are you kidding me? Are you actually kidding me that the state attorney's office, representing the state, is making that allegation to you? That that's ill will because somebody else caught a burglar? Okay, great. Just tie it together, please. You got 2 dots and they're this far away. Just give me a line. Give me something. Stucco guy caught him. George is frustrated. Anything in between besides speculation, assumption, or idiocy? Anything? Sergeant Raimondo, I would want him coming to a car accident that I was involved in. What a guy. What a cop. Did everything he could and did it without even thinking about it. Great cop. Likes his job. Diana Smith. A little bit of just problems with the evidence, the rain, and we'll talk about that. But weather conditions wouldn't allow her to process the items. Touch DNA could have been wiped away, and firearm not given to her. I don't know that it turns out to be a big deal, But there is a lack of evidence here, and we'll talk about maybe why that's there. And who gets the benefit again of lack of evidence? George Zimmerman. Celine Bahadur, you'll have an opportunity, and the instructions will tell you, you assign credibility to witnesses. You decide what to believe and who to believe, and whether or not they're credible. I would suggest that along the scheme as we're going, check out this woman's credibility before you accept what she said. You saw her, you heard her, you saw her review all of her statements as I showed them to her. First time, talked to Mr. Del Riondo last week, first time in court, what shows up? Oh yeah, left to right. Well, here's a thought. Trayvon Martin was running from left to right when he came back towards the area where George Zimmerman was walking. There's a possibility. Could have been. So, I don't know where she fits in, quite honestly. I don't know what she saw, if she saw, or how she saw it, or why she said it a year and a half into it, rather than any of her previous conversations with law enforcement or with me. But whatever. Fit it in however you can. Jane Sudeika, so she heard 3 pops. She lying? Oh my gosh, she's lying because she heard 3 pops. No. Let's get off this lying thing because you have slight inconsistencies. She heard, or thought she heard, what she thought she heard. Okay, whatever. Reverberations, fright, upset, who cares? She got it wrong. What else she got wrong was she thought the big guy was on top. And of course, actually what she really thought was that Mr. Martin, Trayvon Martin, hadn't moved because she saw the whole thing, including the shot, which of course doesn't comport with a 911 call, but again, just stressful time for everybody. She seemed particularly affected by stress. That he was on the ground, never moved, saw the shot was from the top, shot was through the back, and that he never moved. It just doesn't make sense. It's okay. That vantage point that Mr. Root talked about, that movie, I don't know if any of you have ever seen it, but it's a great movie, because it really does. One event happens, it's the president getting shot by a marksman, and then there's 7 different people watching it, and everyone has a completely different story. They all viewed the same event, but they viewed it with their history, with their life experiences, what they were going through that day, and with what perspective they had. And it's just different. That's okay. It happens. Miss Manalo, she heard voices 20, 30 feet to the right, seems to be consistent with it starting at the T intersection. And of course, what she did was what we all do. And I'm not going to assail her for that, but what she did was make some assumptions based upon some facts that she saw afterwards. They're in evidence. It'll take me about 5 minutes to find them. She was looking at pictures of Trayvon Martin when he was 12. I think she said that. So I'll tell you right now, if you looked at me when I was 12 and compared me to anybody, I'm the guy getting beat up. No questions asked. But the reality is that she just had this vantage point of a child at 12 years old getting, I guess, the heck beat out of him by the other guy who was on TV, this big, heavy picture of George Zimmerman. And she acknowledged, now that you showed me the other picture, now here's the ones that I did look at and find out or think that it was Trayvon Martin being the small guy. Now that you show me these other pictures, I could have been wrong. Lying, perjury, no. Come on. Just vantage point, just perspective. And then that's why you're here, because you get to figure it out. Rachel Gentile. Let me give you my perspective on Rachel Gentile. She didn't want to be involved in the case. She didn't want to be involved in the depositions. And she didn't want to be involved in trial. I think what happened, and this is just conjecture, and I'm not supposed to conjecture too much, I think her mom got with Miss Fulton and said, go tell that lady what happened to her son. And she didn't really want to do that. Why she wrote the letter. Why she had or didn't have a conversation. Don't forget, they had only reunited Trayvon Martin and Rachel Gentile like 2 weeks before. Phone records are in, and you know that. They knew each other from school, but never really hung out. 2 or 3 weeks before was when they started talking again. So it wasn't what it was perceived to be, this girlfriend-boyfriend thing. Nothing to do with that. And she just didn't think it was much that night. Interesting to me, just the one thing about Miss Gentile, you know, if you asked me right now to explain to you the phone call that I had 3 weeks ago with my wife, 4 weeks ago with my sister, or last week with Mr. West, I can give you the idea, and then my wife would say, well, we talked about dinner. Oh, yeah, all right, I'm sorry, what's the dinner? No way do you have the recall. But if you're asked to have the recall, tell me what happened. This happened. Did this happen? Didn't he say this? Did he say that? Well, he didn't say, what are you talking about? He said, what are you doing here, right? Oh, yeah. You want that too? Yeah. Miss Gentile didn't want to be here. And I don't want to sound like I'm asking for sympathy. I'm sorry that she had to involve her life in our lives in a way that she never wanted to be involved. Unfortunately, she was a witness, and we had to deal with it. And some of her frailties came out in a courtroom on TV that I'm sure she never wanted out. And probably every other witness. You know, witnesses wanted to be anonymous. You know all that. You know that they were concerned, and she's one of them. Some of the stuff she said was, you know, that it was close to the dad's fiancé place. I actually think probably she meant close as compared to the 7-Eleven. Makes more sense. He took him 45 minutes to go from the 7-Eleven home. Probably was just hanging out at some mailbox. I'll show you the map between the two. Doesn't make any sense that he was hanging out at the mailbox at Retrieve Circle, but whatever. And heard, why you following me for? Somebody said, what are you talking about? Then it changed. I think that change occurred because of the way her initial interview was handled by one of the attorneys. Horribly inappropriate to not get this person to law enforcement. Almost as bad as to have the mom on the couch next to you crying when the state does their first interview of you. Their call, but wow, to do it that way. Of course, she even acknowledged that she was concerned about Miss Martin's feelings, which is why she sort of modified or smoothed over some of the more colorful language and the events that happened. And that's okay. You're supposed to just tell the absolute truth here, but I'm not going to ask someone like Miss Gentile to come in and just not acknowledge the sensitivities of why she may have made it sound a bit better when telling the story of her son's passing to Miss Fulton. Miss McDonald, T-Mobile Records. Miss Lauer. Interesting about her because she sort of, without knowing about it, she gave you some pretty good information when she talked about this three-part exchange, because she was the one who said it before she had any idea about it actually happening. And what she said was, yes, somebody said something, you know, blue car, red car, blue car, blue car, red car, blue car, and yeah, it sounded like that, a little agitated, and then the movement down. That's where we got the movement down on the animation, by the way. She said, T intersection, down sort of past me, and then of course John Good says it happened in front. And that there was only one person yelling for help. That's significant because there is no evidence, none, to suggest there was more than one person yelling for help. And if so, Mr. Guy will remind you of it if I've forgotten. There's no evidence that more than one person was yelling for help. And she was talking about her knowledge and lack of knowledge about the street signs. Miss Moore, we talked about, she heard what she heard, and then she saw what she saw. By the time she saw it and ran around, that's what happened. Greg McKinney, records custodian. John Good, we've talked about him a lot. I think he's a significant significant witness because he watched it for 8 to 10 seconds, and he was the basis for the animation and the information that came to you through the animation. Manalo, Jonathan Manalo, same thing. Looked like he got his butt beat and staggering to the ground. Ricardo Ayala, SPD, the hands under the body. You know, if that is a concern of yours, that my client dared to testify in his statement that he took his hands out out of fear for a weapon, and that is contraindicated because Trayvon Martin's hands, look at the picture, by the way, one hand's not really under him, but the other hand seems to be, that is some inconsistency for which you should impute ill will or hatred or spite. That's absurd. And Dr. DeMaio said it was. 10 or 15 seconds of talking or movement or whatever. Not only is it possible, it's probable. Stacy Livingston, the EMT who was there, you heard all about the injuries and what she did. Timothy Smith, important because, if you remember him, he was the first one on the scene, took George Zimmerman into custody for his own protection. He was the one who George Zimmerman talked to twice about screaming for help before he knew that there was any 911 call suggesting it. Lindsay Folgate, you know about the medical records, and she was the first one to mention MMA style. Hirataki Nakasone, we know about him. Basically, he said, can't tell you, can't help you, don't do it, don't even try. Fortunately, even the FBI couldn't help us out with that voice. So now it is sort of up to you on that. Doris Singleton, initial activity with him with the interview. And I think what was significant about that was George Zimmerman's response to the Christian issue and to the fact that she was the first person to tell him that Trayvon Martin had passed away. And the statements are what the statements are. Chris Serino, again, what he stated was, in his opinion, and again, he's the law enforcement officer in charge of the investigation, that there weren't any significant inconsistencies in what he heard from George Zimmerman. Were there some? Yes. Were they significant in his mind as to what, that they were lies? No, not even when he did the challenge interview. Let's talk about that challenge interview for a second. The state said to you, George Zimmerman knew those video cameras weren't working. So, it wasn't a bluff. It was, again, super cop knowing everything and just deciding, I can get away with this. Really? Really? So when Chris Serino, there seems to be a problem with this. I'm going to look at it for a second. Chris Serino said that, I lost my train. I'm going to catch up in just a second here. What he had said was the inconsistencies did not matter to him and did not change his opinion. And when the confrontation interview occurred, and when George Zimmerman said, thank God there may be a videotape, the state wants you to believe the perfect super cop bluff response because he knows this, because let's not forget, he took a couple of classes a couple of years ago at a community college. Absurd. I would suggest to you, to make a suggestion to you that in that moment, when confronted with the potential of an actual video by Mr. Martin, that my client would do anything other than say, thank God it may be there, and that's not evidence of innocence. Mark Osterman, good buddy, don't think he would lie for his friend, but was the one who testified about the self-defense, and I think you remember his testimony, a little bit animated, but sort of told you all about everything he could about both George Zimmerman that night, that he wrote a book about it, that his story is a little bit different from George's other stories. Figure it out, and figure out how significant it is, and whether or not it suggests second degree or anything. Now, Dr. Rao, I don't know what to say. Minimum of 4 hits. Okay. You see the pictures. If you think George Zimmerman was only hit 4 times, fine. Let's take a moment on those 4 hits. You're going to get the statute, you're going to get the jury instructions, and here's what they're going to tell you about the extent of the injuries that you have to find my client suffered at the time he decided to shoot. The significance of those injuries, how life-threatening those injuries were, how soon my client presumed he was going to die from the injuries that were already inflicted upon him. Are you ready? 0. 0. No injuries necessary to respond with deadly force. Not a cut on a finger. The statute is clear. Reasonable fear of bodily harm. Captain Carter told you, whoa, you can get reasonable fear of bodily harm when you're already getting your butt beat. That's certainly an indication. But do you need a cut on your finger? No. Of course, getting a cut on your finger doesn't allow you to just shoot somebody unless you're in reasonable fear for ongoing great bodily injury. So the injuries, icing on the cake of self-defense, has nothing to do with the substance of self-defense. Not a thing. You will not hear a word about inflicted injuries. You will only hear that you must look at George Zimmerman's state of mind when he did what he did. So, even if I said to you, I'll take Dr. Rao's testimony, though you can tell I wasn't taking Dr. Rao's testimony. But let's just say I was. It doesn't matter. Ms. Benson, print expert, there wasn't a lot. Absence of prints doesn't mean no fingerprints or no touching, just that it's not there. Environmental factors such as rain could remove them. Lieutenant Scott Kieran's, the application that was denied because Mr. Zimmerman didn't have good credit. Captain Carter, criminal litigation coursework, he actually turned out to be a good expert to tell you what self-defense is and how getting your butt beat is really probably a good indication that great bodily injury is coming because it's already started. And he says, not a good idea to wait until it actually, you get attacked. Jim Krasinski, records custodian. Gordon Pleasance, we talked about it, taught the course online to Mr. Zimmerman. Amy Seward, firearms. She mentioned the full round of bullets, full complement of bullets, and I think we had good testimony about that. Anthony Gargone, FDLE, talking about DNA. You know, the problem with part of that DNA, they got some. I think they missed a bunch, or at least some, because of the way it was packaged. Significant? I don't know. I don't think it was that significant. There may have been more blood. I don't think that George Zimmerman was bleeding a lot that night. I don't think he was bleeding a lot out that night. I think he was probably bleeding a fair amount in. And then when he stood up after the attack was over, yes, it started coming out of his nose. Not a lot of blood on Trayvon Martin. Probably not a lot to be expected. And there was no injuries on Trayvon Martin until the gunshot, so you wouldn't imagine there would be any blood on George Zimmerman's hands or any place else in his body, because when Trayvon Martin was finally shot, he went up and over. So DNA, we can go over some particulars about it, and I have some precise points about what was found on Mr. Trayvon Martin's cuffs and whatnot, but generally speaking, not all that significant. Miss Fulton. People asked why I even questioned her. How dare you question the mom of a passed away 17-year-old? Doctors cut people sometimes when they do their work, and that was something that I had to present to you, to something about the way it happened and how it happened, and you know, the impact and just how moms think about these things, both sides. Because I know that both moms believe with their heart, with their soul that that was their son screaming for help. You have to, and you want to, and it's just the way you get through it. DeVaris Fulton, the brother, he really didn't know. I think he told you in his testimony when he was talking to the NBC affiliate, yeah, it could have been him, not certain, might have been, I think it was. And now he's more certain. Well, again, I'm okay with that. I'm okay with people wanting to hear what they want to hear. Mr. Bao, Dr. Bao, that was the state's decision to bring him before you as a medical examiner. Not really, it's actually their decision. He was the one who did the autopsy. So, although there was some interaction there that might have best been just redone, the reality is the only injuries were the injuries that we know about on Trayvon Martin, and that the wet clothes should not have been bagged in paper, and that the hands should have been bagged. And we'll talk about the hands in a little bit. Miss Zimmerman told you that it was her son, as I'm sure you expected before she ever got on the stand. Jorge Mesa, interesting, because that was unplanned by him, it would seem, if you believe his testimony, sitting at a computer listening and then hearing in the background a voice that he knew without question and immediately to be that of his nephew, George Zimmerman. I think he came across very credibly. I think he came across a man of his oath and of his word, and I would ask you to consider the testimony in that regard. Mark Osterman, buddy of his, talked about the weapon use, how you holster a gun. You know, he's good at what he does. He was helping George figure out how to fire a gun. Sandra Osterman, friend, definitely George Zimmerman, screaming for help, and explained away some of what the state was trying to prove to you through the non-emergency call about the anger and hatred and all that just isn't there. Same thing with Miss Jerry Russo, no question in her mind, George's voice. Same thing with Leanne Benjamin. Has heard him scream and yell in campaigns, and that was George Zimmerman. John Donnelly was interesting because I'm not sure that I could, if I had thought about trying to figure out who in the world talks to people they know and then hears them scream for their life. I just, there's no profession that does that. Maybe a cornerman in a boxing ring, but they don't scream for help there. A medic in Vietnam. A person who hangs out during the day with his buddies of 60 to 100 people, figures out who they are, what they are, who they left behind at home, when they want to go back, when they might go back, and when, you know what, that they might never go back. Because he's the guy who grabs a medic bag and the rifle, I think he said, and heads out towards the screens. And that even before he gets there, sometimes, he knows who it is who's screaming. Wow. Didn't want to testify. I don't think a guy who's been in Vietnam wants to come before people and break down a little bit. But I think that his testimony was quite credible when he believed it was Mr. Zimmerman. Doris Singleton and, by the way, Chris Serino both say the same thing. Unfortunately, when Mr. Martin did first hear the tape, he said what he believed to be true then, it would seem from the officers, and that is, that's not my son's voice. It just wasn't his voice to him. And his mind has changed now. But it is interesting for you to consider when you're trying to figure out that issue of who said what and what witnesses said what, because you're going to give them credibility, you're going to weigh them, you're going to decide to dismiss their testimony or to accept their testimony. And try and figure out, remembering always, as we'll talk about in a moment, the benefit always goes, or the doubt always goes to my client's benefit. Adam Pollock, animated, good guy. George is soft. He's a 1. I don't care that he's been here for a year. I'm not sure I would have actually advertised that I trained George Zimmerman for a year and brought him from a 0.5 to a 1, but he did. Not a fighter, not got off a bag. So this MMA, you know, George, I think the statement said it was 18 months that George was MMA training 3 days a week. Urgh. Really? Come on. Really? In light of the testimony of the trainer who said, I wouldn't even let him do anything but shadow box for fear the shadow might win, and hit a bag. Tracy Martin we talked about. Chief Bill Lee, he was there for the whole part of it, but most importantly, he was the officer who said, whatever you do, separate them. Don't infect witness testimony with other witness testimony. It is COP 101. I understand the sensitivities of them being family members listening to the possible voice of their son and definitely the gunshot that ended their son's life, but law enforcement, ongoing investigation, just put them in one at a time. The way it was handled infected the evaluation of that testimony horribly. And who gets the benefit of that? George Zimmerman. Vincent DeMaio, just the grandfather. He's done this his whole life. Came in and gave you some really good information about everything having to do with gunshots. Really good because he failed and refused to go beyond gunshots, even when I think we tried to take him a little bit, and he said no. And then the state tried to take him a little bit, and he said no. I'm good at what I'm good at, but I'm only going to talk about what I'm good at. And what he's good at is gunshot wounds, and suggesting that it made perfect sense that the can in the jacket would do what it did. Does it make anything less than perfect sense as to what happened? It's in there, and he's leaning over. And his loose, billowing shirt falls forward. And he gets shot. And it's contact to the fabric. It is not pressed against the chest. I think that little play in opening statement has been dismissed. And it was 4 inches from his chest. As it turns out, the type of forensic evidence is fairly significant because it completely supports the contention that Mr. Zimmerman was on the bottom, Trayvon Martin leaning over the top when he got shot. Now, here's a theory of guilt for you. You ready? Because this is the state's presentation, so listen carefully. He might have been backing up. He could have been backing up. Could have been. If I was arguing that, I would be arguing to you reasonable doubt. You know, it could have happened this way. It could have been that he was backing up. Well, I don't know. I almost made light of it when I said, well, he could have been backing up to strike another blow. But the could-have-beens don't belong in this courtroom. Proof beyond a reasonable doubt. Consistent with a reasonable hypothesis of innocence, he was leaning over him. Nothing to suggest anything else but that. He could have been leaning back. At some point, after 45 seconds of attacking George Zimmerman, for no other reason, let's not forget, he didn't back up when John Good told him to, right? So for some reason, just before the shot takes off, at that moment, the state wants you to believe Trayvon Martin retreated. Really? Really? One piece of evidence, just one I asked for, just one piece of evidence that supports that contention. Where is it? Where's the eyewitness who said, I saw him back up? Where's the forensic evidence? Where he got all the way back up? Chest and shirt are tied together and shot is through and through. Where's that piece of evidence? Where is one shred of evidence to support the absurdity that they're trying to have you buy? One, Mr. Guy can tell you about it when he closes, if it's there. Assumption, supposition, could have been. Bona fide, just part of the absurdity of how this thing happened with the phone call, with the tape. I don't think it matters too much. Miss Dilligard, nice lady, didn't want to bring her here sick. Knows George Zimmerman, saw him that night, saw him beat up, saw the picture, or hit, saw him hit. And that he has a light voice, and it sounded like it was his voice. Dennis Root, it's interesting. Again, talk about the Bizarro case. Now we have prosecutors attacking, sort of impeaching, lifetime law enforcement officers who have dedicated their life to the pursuit of perfection in law enforcement. Perfection. My God, he's trained in everything. He takes something on, he becomes a trainer. And now we have the state impeaching. Well, hold on a second here. Could have been this way, right? Not really. Well, let me ask you this question, Mr. Guy says. At that moment, George Zimmerman decided to shoot Trayvon Martin. What other options did he have? None. He had none. From a use of force expert who's been doing this his entire career and who has become proficient in assisting others in learning how to use force, learning how not to use force, learning when to use force. And they asked him the question of whether or not George Zimmerman had alternatives. Tell me the piece of evidence that contraindicates that. Just give me one. Give me a shred of evidence that contradicts that he had any other option. Because now we have an expert who's qualified, who gave you that opinion. Dismiss it if you want. The judge will tell you, just because they're experts doesn't mean it's gospel, that you have to listen to them. But if you believe them, if you think they're well qualified enough to give an opinion, if it's an area of inquiry which will help you, then accept it. Miss Bertolon, I hope it does not come across that I was just seeking sympathy for this woman. But the reality is, I think when you put a face on what was happening at Retreat View, she's it. She really is. Because thank God nobody came upstairs. I'm not sure the scissors would have really helped. But that's the face. And I'll tell you this, I'll give you this much. That's the face of the frustration that I think George was feeling a little bit of. You know, that's something that he wanted to help out with. That's why he walked over and didn't say, I'm going to go get this guy. No. That's why he said, here's a lock for the back of your door. Here's my telephone number. And here's my wife's number. You need our help? This is what we do. We help. Dad. You know, he said it early. You got to give it this much. He said it right away. He went down to SPD to talk to them, Sanford Police Department. They put him under oath, or maybe the state attorney's office. They put him under oath and said, okay, now, you're under oath. You got to tell the truth. Is that your son? Yes. We talk about a few other points, if I might. Oops. Because this is not working. it might come back. If not, I'll just read it to you. If there's any chance it'll come back up, that'd be great. If not, I'll just work without it. Some of the things that you ought to consider when you look at this case is the forensic evidence, what it does and doesn't support. Here was an interesting thing that I didn't make a big deal about in the trial, but I want you to focus on, because a lot has been said about the lack of blood and what happened to the blood. And well, if Trayvon Martin was doing what George Zimmerman says Trayvon Martin was doing, where's the blood? Where's the anger? Where does it show up on the hands? State 28. Gunshot wound. See the blood trickling down and across the chest? See that 3-inch swath of blood all the way over there? It's 895. It's gone. Not there. Yet, everybody who handled that body said they didn't touch it or they didn't wipe it. They may say, well, that was when we moved the sweatshirt up and we moved it back down and the blood is all gone. Well, let's not forget, the blood was there after they moved the sweatshirt up. So why wasn't it there if they moved the blood down? And it was actually still oozing in this photograph. So, some big moment. I proved my case? No. But the idea that they want you to assume, that they want you to believe, just connect the dots, that there was no blood because there was no blood when they failed to properly preserve items like the sweatshirts, items like the body, it seems, items like the hands that were to be bagged but weren't. They don't have to prove beyond a reasonable doubt that they bagged the hands. That's not an element they have to prove. But if they're going to try and come up with conclusive evidence that supports no other reasonable hypothesis of innocence but guilt, then they have to have a better case. And this is just some evidence of it. So, let's talk about other things you have to consider about that event. A couple of graphics. George Zimmerman, the way he was. Trayvon Martin, the way he was. Now let's do it life size. Trayvon Martin that night. He was wearing shoes I have to show you. He had the hoodie on. On top of the hoodie, this is from the picture that we showed you. It's not in evidence, just to have you look at it. Don't even have to believe it's accurate. Just take a look at it. Remember how much taller I was than Andrew Gall when I was standing next to him, and he testified that he was 5'10". And then there's George Zimmerman, and how tall he is. Take a look at him compared to my eye height. George, stand up a minute, please. Thank you. Relative physical abilities. That's what you have to look at and determine in a self-defense case. So, you look at this guy that night. Don't look at him today. There's been testimony all over the place as to how much weight he gained. It doesn't really matter. What matters is how he looked that day and how Trayvon Martin looked that day. The other thing that's in evidence, just so you get a clue, or not a clue, an indication, November 15th, 2011, about 2 months, 3 months before Trayvon Martin passed away. That's what he looked like. He's a young kid. Nice kid, actually, if you look at the picture. Not bad. The problem with it is that when we show you autopsy photographs, there are 2 things you need to know about autopsy photographs. One, they're horrific, and they're meant to have negative impact. I did it when I was a prosecutor. Prosecutors do all the time. A dead person on a slab has an impact on you. I would say that maybe one of you, maybe, have looked at a picture like that before this trial. Maybe one. It has an impact. The other thing about autopsy photographs is that there's no muscle tone because there's no nerves, there's no movement. He lost half his blood, we know that. So on that picture that we have of him on the medical examiner's table, yeah, he does look emaciated. But here's him 3 months before that night. So it's in evidence. Take a look at it. Because this is the person, and this is the person who George Zimmerman encountered that night. This is the person who, all of the evidence, was attacked, or attacked George Zimmerman, broke his nose or something close to it, and battered him on something. And the state now may say, oh, maybe it was just a drain box and it was no intent to hurt there by Trayvon Martin because it was just coincidence that he was bashing his head on something hard and it was a drain box. Really? Come on. Really? Those injuries? You know how Doctor was out that night? You've seen this before. It was out of this darkness that Trayvon Martin decided to stalk, I guess, plan, pounce, I don't know. All I know is that when George Zimmerman was walking back to his car, out of the darkness, be it bushes or darkness or left or behind or somewhere, Trayvon Martin came towards George Zimmerman. Out of this. And we know what happened. The big picture is what happened. And it's supported by evidence. You know, we talked a moment ago about ignoring George's statements. You know what? Don't ignore them. Listen to them. Find the inconsistencies in them. See what you think about them. Take him in context of what he was going through that night and how voluntary he gave all of those statements, and decide whether or not, as Dennis Root said, as Chris Serino said, as I believe Singleton said, if anyone is giving me the same exact story twice, they're probably lying. They're probably pathological liars. Because when you lie, I guess, since you're making up a fantasy, you can tell the fantasy twice, the same exact way. But if you get your nose smashed or your head smashed and you try and do what you can, and you're answering every question they ask of you, then yeah, okay. Deal with the inconsistencies however you want to. But maybe I would suggest you begin by dealing with them the way Chris Serino did, since it was his case. And what he said to you was, yeah, there was some inconsistencies. He said he got hit 25 times. I don't believe it. It seems he didn't get hit 25 times. Did it feel like he was getting hit 25 times? Maybe. Is that the embellishment, the exaggeration the state is talking about when they say to you, oh, he's exaggerating, he's a liar? He's a liar? Really? Come on. Those are lies. If you lie, it's normally with intent to deceive, isn't it? Isn't that the essence of a lie? if George Zimmerman had the intent to deceive, why would he give 6 statements? If you're going to give him credit for anything about going to school and going through legal studies, here's one: Miranda. He knows self-defense. He knows stand your ground. He knows whatever the state wants you to think he knows, but he doesn't know Miranda? Oh, no. He knows Miranda, but he was such the mastermind that he could, without knowing any of the evidence, who was watching, who was videotaping, who was doing anything, without knowing any of that, he had it all sussed. He had it all figured out, really. It defies explanation. What doesn't defy explanation are things like this. The mud on the knees, evidencing the mounting. What doesn't defy explanation is Officer Tim Smith's testimony that George Zimmerman's back was wet, more wet than the front, and that he had grass all over his back, evidencing, I would opine, that he was on his back in the grass. And he was getting beat up. Manalo, Tim Smith, Wagner, everybody else who saw those injuries. Okay. You don't get graphic, but you do still get me going over some of the instructions with you. Reasonable doubt. What is it? Can't tell you any more than we have. The judge has read it to you a couple of times already. You're going to get it again. Reasonable doubt. Don't start with the premise. Presumption of innocence sticks and stays until it is taken away by evidence that convinces you beyond a reasonable doubt that it is no longer appropriate to consider Mrs. Zimmerman innocent. Then and only then do you get to convict my client of anything. A reasonable doubt is not a mere possible doubt. If you got to make it up, that's not a reasonable doubt. We talked about me proving my case as though I had to. It's not a speculative doubt or an imaginary doubt or a forced doubt. If you have a doubt and you say to yourself, I don't buy this doubt, but I'm going to force myself to believe it, that would be a forced doubt and isn't reasonable. But a reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, and this is the meat of it, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or of having that conviction, it is one which is not stable, one which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, every reasonable doubt, and you must find George Zimmerman not guilty because the doubt is reasonable. I almost wish, and I've never said this in a criminal trial before, I never heard it being said before, I almost wish that the verdict had guilty, not guilty, and completely innocent. Because I would ask you to check that one. You've got to check the not guilty, but check the innocent then too. A reasonable doubt as to George Zimmerman's innocence may arise from the evidence, conflict in the evidence, or a lack of evidence. If you have a reasonable doubt, you should find George Zimmerman not guilty. If you have no reasonable doubt, you should find George Zimmerman guilty. Weighing the evidence, you'll have all of this before you. Judge Nelson's going to read it to you, and she's going to give it to you. But just to focus on what you do about these witnesses, the question is whether or not they had the opportunity to see and know the things they're telling you about, obviously. And that's that vantage point concern, how they really can look at it. The perception you have to see. For example, if somebody came in, wasted off their mind, then give them less credibility. We don't have that here, but you got to look at it and decide whether or not they had an opportunity to see what they're talking about. Do they have an accurate memory? And we know that memory is affected by traumatic events. I think Ms. Sudaika is a good example of that. She was frantic about what she perceived was happening outside. And I think it may well have impacted on her ability to recall, not calling her anything but a person affected by the circumstances. Were they honest and straightforward? I would put up on that pedestal Miss Bahadur. Your call, but as to whether or not she presented in a way that made some sense. Compare her to Miss Mora, who just seemed to be saying what's remembered and very willing to show you. Did they have an interest in the outcome? Well, let me tell you something. When George Zimmerman gave those statements to law enforcement, he didn't know it, I don't think. Didn't seem normal that he would have ever been charged in this case, but in his mind at that time, I presume you could say that he had an interest in telling the story as good as he could for himself. So, sure. Was there an interest in the outcome? Absolutely. These people trying to take away his liberty? Absolutely. Consider that when you look at those statements as well. And does the witness's testimony agree with other testimony? That's the global view. Dennis Root kept saying to you, well, you have to look at it in the totality of the circumstances. Don't just give me one sheet and go, well, what do you think now? I want to read everything I can. That's the same thing. That's that totality of the circumstances. So, rules for you to deliberate under, and here they are. The case must be decided upon the evidence. Sort of makes sense. But that was I started, 2.5, 3 hours ago. I started with the idea that you need to be very careful not to do the assumptions that you might otherwise do at the state's request. It is only the evidence and the witnesses that you can look towards for that. Upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of exhibits, all that really means to you is, though you can bring your common sense, don't bring your assumptions, don't bring your presumptions, and don't sit back and just go, I really think that guy's not going to cut in front of me as I drive to work today. You don't have that luxury in a criminal courtroom. You don't. You only get to decide upon what you are certain of, something that you do not have a reasonable doubt about. Don't do it because you feel sorry for anyone. Now, I said to you, and you may not have realized, I think you realized why, but the significance of it now comes back home. I said to you, if the state doesn't prove their case, you're going to be able to say something to announce a verdict of acquittal, even though that verdict has to be heard by the Martin family? And you said you could. I meant that for a very significant reason. It is a tragedy, truly. But you can't allow sympathy to feed into it. When I say that to you, you should sit back, someone should raise their hand and go, are you nuts? How dare you tell me to leave sympathy out of my life? How dare you tell me to leave all of my emotions besides? How dare you? I don't do that ever in my life. Welcome to a criminal courtroom, because unfortunately you have to be better than your presumptions. You have to be better than what you do in everyday life. Better, at least different, at least unique. Verdicts should not be influenced by feelings of prejudice, bias, or sympathy. It must be based on the evidence in the law, period. And the judge will tell you what the law is. And now we have to talk for a moment about self-defense, because we've talked all around it, and let's tell you exactly what the judge will instruct you as to what it is. A person is justified in using deadly force likely to cause death, if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. There are alternatives, death or great bodily harm, so I'm going to go through this and tell you that what you need to consider is whether or not George reasonably believed, reasonable fear of great bodily harm. He doesn't have to think he was going to die. He does not have to think he was going to die. He does have to think that he was going to be injured greatly. And since the alternative, if either matches, it's been met. In deciding whether or not George Zimmerman was justified in using deadly force, you must judge him by the circumstances which he was surrounded with at the time the force was used. The moment of using the force, what was happening. The danger facing George Zimmerman need not have been actual. Now, getting beat up sort of takes that better in context, but it doesn't have to be actual. In effect, I guess, the knife coming at you could be rubber, as long as you perceive it to be steel. Or the next blow of a fist could be a fake one, but as long as you perceive it to continue to be blow down upon you, then that's enough. The danger that George Zimmerman faced need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under those circumstances, reasonably prudent and cautious person under those circumstances, got to put yourself in effect in the mind of what George Zimmerman was going through, the circumstances that he was going through, and then decide yourself whether or not that a reasonably and cautious person under those circumstances would have believed the danger could only be avoided through the use of that force. Based upon appearances, George Zimmerman must have actually believed the danger was real. In considering self-defense, and again it's called justifiable use of deadly force, we shorthand it to self-defense, you may take into account the relative physical abilities and capacities of George Zimmerman and Trayvon Martin. If your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether George Zimmerman was justified in the use of deadly force, you should find George Zimmerman not guilty. And let me show you what that means in layman's terms, because I don't like the fact that I'm trying to prove to you a double negative. It just seems awkward. If you have a reasonable doubt on the question of whether or not George Zimmerman was justified in the use of deadly force, you have a reasonable doubt as to whether or not he was justified in the use of deadly force. He's not guilty. Anywhere along this graph, if you believe, this is where I went a little while ago, anywhere along this graph, then he's not guilty. That's why I said this was the bizarro case, of showing a case like this and wondering whether or not there is a reasonable doubt as to whether or not he had to use that deadly force to protect himself from great bodily harm. The other thing that I think we've probably gotten past, but I want to be clear about, is this one. You're going to get all the law that applies in this case. Every shred of law that applies to this case, you will have before you. What you won't have is any law that suggests something like following somebody is illegal, because it's not. Following somebody in the car or on foot in order to report their whereabouts to the police is not unlawful activity under Florida law. If it was, you would be instructed on it. You would have a statute as part of your jury instructions that says something that George Zimmerman did was unlawful. And you won't have it because it's just not there, because it's just not true. I'm over my time. I'm going to finish up quicker than I would like to. I cannot imagine that I've actually been here for 3 hours, but I want to do a couple of quick things and to show you, since this is the state's burden, what they haven't proven about it. I don't think it's a big deal that they decide not to give you the 6th emergency or non-emergency call. Just, they should have, just to be complete. But whatever. I don't know, the fact that I had to call Tracy Martin to have him testify to that when it's the state's case, I guess that they didn't have to do that. But if you're really seeking justice, why have me do it? Why not even have Serino testify? Why did I have to have him testify that Tracy Martin said it wasn't his son? Why did I have to have Singleton testify? Certainly they're available to me, and I did it. And I guess if I can do it, the state doesn't have to, except, it really and always will be their burden, not mine. They didn't tell you about all the other burglaries that happened at Retreat View. I did. They're there. I haven't highlighted them, but trust me, they're there. Where's the expert countering use of force? Where's their guy? So all we have on use of force now is Dennis Root. Again, they don't have to bring a use of force expert. I did. They don't have to. But if that's their issue, where's their information? Same thing with Dr. DeMaio. I guess they sort of had Dr. Rao. Well, no, not on gunshot. But where's that? Again, they don't have to, but this is their case. I mean, it affects George Zimmerman, but it's their prosecution. It's their burden. That he pushed the gun into Trayvon Martin's chest. Justice and emotions, you got to be careful with it, because we all have emotions as human beings, and then we have justice. And you sit back and you go, what are they trying to do? Does it really help you decide this case when somebody who is not George Zimmerman's voice screams at you or yells at you and curses at you? No. I would contend, listen to the tape. Don't listen to Mr. Guy. I'm sure people say that I look like Joel Osteen, and I think Mr. Guy is trying to sound like him with this really long effing punks. Do we need that? I do a little bit, I guess. But do we need that type of anger coming out from a prosecutor rather than from a defendant? Is that really the way we're going to present this case to a jury of my client's peers? Assholes. Really? Is that the way he said it? One piece of evidence that my client attacked Trayvon Martin. Landed one blow, for that matter. Did anything to justify in any form or fashion the onslaught of injury perpetrated upon him by no one other than Trayvon Martin. He actually had something else, because George Zimmerman was, in fact, armed with a firearm, and we know that. We know he had the right to have it. And then it was said, how many times was it said that Trayvon Martin wasn't armed? Now, I'll be held in contempt if I drop this, so I'm not going to do some drama and drop it on the floor and watch it roll around. But that's cement. That is a sidewalk. And that is not an unarmed teenager with nothing but Skittles trying to get home. That was somebody who used the availability of dangerous items from his fist to the concrete to cause great bodily injury. Not that it's necessary for self-defense, but great bodily injury against George Zimmerman. And the suggestion by the state that that's not a weapon, that can't hurt somebody, that can't cause great bodily injury is disgusting. Even if we presume Rachel Gentile was completely accurate in whichever version of what she first heard happen you want to believe. What she said was that George Zimmerman said, "What are you doing around here?" Let's just for a moment presume that we had that on audio tape. Let's just say they were recording their phone call and you heard her voice. Oh, you heard George Zimmerman's voice on the tape that said, "What are you doing around here?" What did Mr. Root say about that? What did the only expert that talks about the evolution of force tell us? Well, you say something like that, I might say, whatever I want, or who are you to ask, or what do you mean, or get out of my face. But Dennis Root didn't say that the appropriate response is to break somebody's nose. Did he? Did he suggest that that was even near the spectrum of violence allowed, or the spectrum of force allowed in a situation like that? Unfortunately, there was some anger and hostility and ill will and spite maybe that night. It just had nothing to do with George Zimmerman. Well, that's not true. It had something to do with George Zimmerman. He was the victim of it. Because you can't look at those pictures and say that what was visited upon George Zimmerman was not evidence of ill will, spite, and hatred. Had Trayvon Martin been shot through the hip and survived, what do you think he would have been charged with? Aggravated battery? 2 counts? The state has to convince you beyond a reasonable doubt, you have no doubt in your mind that my client is guilty of anything. You get trial hypnosis. You think that you say the right things whenever you talk as a lawyer. So within that context, I really feel like I may have convinced you beyond a reasonable doubt that Mrs. Zimmerman is innocent. But of course we know that has nothing to do with it. The state will get up and finish in just a couple of minutes, and they will tell you he's a liar again. Maybe not, because Mr. Deliano spent most of his time convincing you that my client lied. But here's the standard. You go back there. First thing you might want to consider doing. Do you have a reasonable doubt that my client may have acted in self-defense? Go back there and say to yourselves, let's just forget the crimes, let's just talk about self-defense. Do we think he might have acted in self-defense? Not convinced. I have some doubt, have some concern that he just may have acted in self-defense. And if you reach that conclusion, you get to stop. You really do. Why? Because self-defense is a defense to everything. To littering, to speeding, to battery, if it mattered, to grand theft, to assault, to manslaughter, to second degree. You go no further than a determination that the state, now that we're done and there is no more evidence, that the state has not convinced you beyond a reasonable doubt that George Zimmerman did not act in self-defense. It's an easy decision. And I don't say that out of hubris or just ego, I'm saying it because of the facts of the case. You look at these facts, you look at all this evidence, and you have to say, I have a reasonable doubt as to whether or not the state convinced me he didn't act in self-defense. That's all you have to do. You don't have to write innocent on the bottom of the verdict form. We don't go anywhere near those in this courtroom. The state never, ever loses their responsibility to take away reasonable doubt from you. Don't let them do it with innuendo. Don't let him do it with sympathy. Don't let him do it with yelling. Don't let him do it with screeching, because none of that matters. Because we have a definition of reasonable doubt, and now you do. You look at that definition, you go back to that room and say, let's talk first about self-defense. If I think George may have acted in self-defense, we are done. So, thank you for the time. Thank you for the attention. Again, we talked about it way in the beginning, an amazingly difficult task that we've asked you to take on. And we all have had juries a couple of whom we had to wake up on occasion. You're certainly not those. The note-taking, the interest, it's been apparent. I appreciate the time. My client does, the state does, I'm sure, the court does, and Seminole County does, because you've given us what we needed from you, which is your attention. I want one more thing from you. I want you to really, really look at those instructions, apply them, and just say he acted in self-defense, find him not guilty, let him go back and get back to his life. Thanks.
Thank you, Mr. Romero. Ladies and gentlemen, do you want a brief break before Mr. Guy get some? Let's go ahead and take a 10-minute recess. Please follow Deputy Jarvis back into the jury room. Put your notepads face down. Please be seated. We'll be in recess for 10 minutes. Please be seated. We're back on the record. Are we ready to bring the jury in? Defense ready?
Thank you, Ronnie. Yes.
Please be seated. Mr. Guy, you may proceed.
May it please the court, counsel. Good afternoon. The human heart, it has a great many functions, but is not the most important purpose what it causes us to do. It moves us, it motivates us, it inspires us, it leads us, and it guides us, our hearts, in big things like what we choose to do for a living, and in little things, like what we do every day, at any moment in the day. So if we really want to know what happened out there behind those homes on that dark, rainy night, should we not look into the heart of the grown man and the heart of that child? What will that tell us about what really happened out there? That's what was in George Zimmerman's heart. And the defense attorney can make fun of the way I say it, but it's not my voice that matters. It's yours. And we're about to hear from you. What does that say to you? Was he just casually referring to a perfect stranger by saying effing punks? That doesn't evidence to you anything? That's normal language? Or is that not what was in that defendant's heart when he approached Trayvon Martin? What does that tell you? It's funny. He put on a timeline that was 10 feet long, and the only thing he skipped was those two words at the bottom of the screen. It was the only thing. Think there was a reason for that? Think your reason he didn't want you to think about that again? How powerful that is? What that defendant was really feeling just moments before he pulled the trigger? Think that was a coincidence? What was in Trayvon Martin's heart? Was it not fear that Ms. Gentile told you about? The witness who didn't want to be here, the witness who didn't want to be involved. But the witness, the human being that was on the phone with the real victim in this case, Trayvon Martin, right up until the time of his death. Was that child not in fear when he was running from that defendant? Isn't that every child's worst nightmare? To be followed on the way home in the dark by a stranger? Isn't that every child's worst fear? That was Trayvon Martin's last emotion. There's a old saying, great one though. As a man speaks, so is he. The words on the screen were the last thing these people said before Trayvon Martin was murdered. Before this defendant had a motivation to lie, to justify his actions, what were his words? What was in his heart? If ever, there was a window into a man's soul, it was the words from that defendant's mouth on that phone call. And if ever there was a question about who initiated the contact between that grown man and that child, it was again those defendants' words. when he told Sean Nofke, just have the officer call me on my cell phone, and I'll tell him where I am. George Zimmerman was not going back to the car, or the clubhouse, or the mailboxes. And if there was ever any doubt about what happened, really happened, was it not completely removed by what the defendant said afterwards? All of the lies he told, all of them. What does that tell you? There's only two people on this earth who know what really happened, and one of them can't testify, and the other one lied. Not about little things like his age or whether or not he went to the hospital, but about the things that really, truly matter. And not one lie, over and over and over again. What does that tell you about what really happened out there? Why did he have to lie if he had done nothing wrong? The bottom line is, think about this. If that defendant had done only what he was supposed to do, see and call, none of us would be here. None of us. But that's not who he was. That's not where he was that night in his heart. After months of these people getting away. Not tonight. Not this one. Not that guy. That's why he got out of the car. If he really wanted the police to get Trayvon Martin, what would he have done? He would have stayed in his car and driven to the back gate where he had told them so many times they always go through the back gate. And he would have waited for the police. But that's not what he had in his heart. Trayvon Martin may not have the defendant's blood on his hands, but George Zimmerman will forever have Trayvon Martin's blood on his. Forever. Let me give you one more old saying. Maybe the most important one you're going to hear. And that is, to the living we owe respect, but to the dead we owe the truth. On behalf of the state of Florida, I submit to you that Trayvon Benjamin Martin is entitled to the truth. And it didn't come from that defendant's mouth. It didn't. He told so many lies. That's why we're here. By the end of the night, that is what was in Trayvon Martin's heart. The defense attorney said, what evidence is there that the defendant followed Trayvon Martin after he said okay? He challenged the state. Well, I've got an answer. What happened after 1913-43, when that defendant hung up with Sean Nofke? In 1915-44, when Rachel Gentile heard the thump and the end of Trayvon Martin's life. The defense attorney gave us a nice demonstration of what happens in 4 minutes. Well, what was that defendant doing for those 2 minutes? Watch the walkthrough again. Watch it. Because he tells you exactly where he hung up. He's walking back in the direction of the T, and he says, I got off the phone and I continued to my car. Maybe 10 seconds before he got to the T. It was 2 minutes. 2 minutes. He wasn't going back to his car. Four minutes is not the amount of time that Trayvon Martin had to run home. 4 minutes is the amount of time that Trayvon Martin had left on this earth. I don't have any audio clips for you, or video clips, or charts, or big, long, 10-foot long timelines. I'm asking you to use your common sense. Use your heart. Use what you know is real. Use what you know you've heard in the law in this case. You know, and for the defendant, it's kind of like their little animation, the cartoon that they put up. Everything they want you to think in this case starts from the T, just like their little animation starts from the T. Don't do that. That's not fair. That's not fair. It'd be like reading the end of a book, the last chapter only. And you'd be asking yourself, why are we here? How did we get here? Who are these people? You can't do that in real life, and you shouldn't do it here. Let me suggest to you, you start at the beginning. Let's start at the 7-Eleven, where that child had every right to be where he was. That child had every right to do what he was doing, walking home. That child had every right to be afraid of a strange man following him, first in his car and then on foot. And did that child not have the right to defend himself from that strange man? Did Trayvon Martin not also have that right? I don't have all the fireworks, all the animation, but come back with me. Come back with me to that scene where it happened that night. Come back with me and bring with you your God-given common sense. The common sense that tells you it's the person talking like the defendant who had hate in his heart, not the boy walking home talking to the girl in Miami. Wow. The common sense that tells you if Trayvon Martin had been mounted on the defendant, as the defendant claims, when he went to get his gun, he never could have got it. I don't have to pull out that mannequin again and sit on it. You remember. If you have to, do it in the jury room. If he was up on his waist is covered by Trayvon Martin's legs. He couldn't have got the gun. He couldn't have. They wanted a reason. It's a physical impossibility. He couldn't have grabbed it. The only way that defendant gets to his gun, the only way Trayvon Martin was getting off of him or he had backed up so far on his legs that he couldn't hit him, couldn't touch him. The defendant didn't shoot Trayvon Martin because he had to. He shot him because he wanted to. That's the bottom line. The common sense that tells you if Trayvon Martin had already run off like he claimed in his interviews, why would he go through the end of the T to get an address? If he had already run off, does that make any sense? Of course not. It's self-serving. It's justification. It's false. The yelling. Listen, please listen to that tape again. Jen Lauer's 911 call. Listen to when the screaming stops. At the instant of the gunshot. Silence. Nothing. If that defendant thought he missed Trayvon Martin, thought Trayvon Martin was still alive, so much so that he had to get on his back, flip him over, spread his arms out, why would he stop yelling for help? Why, if he was in fear? Does that make any sense? Of course not. If he was yelling that loud and that long, would he have sounded the way he sounded on the recordings that you have? He wouldn't have been hoarse. He wouldn't have had a strained voice if that was him yelling. Really? That's why common sense is so important. This isn't a complicated case. It's a common sense case. And it's not a case about self-defense. It's a case about self-denial. George Zimmerman. The common sense that tells you if he was the neighborhood watch coordinator, not anyone, the coordinator, who had lived there for 4 years, he'd know the name of Twin Trees Lane. The common sense that tells you if he was so afraid of the real suspicious guy with his hands in his waistband, he'd have never got out of the car. But that's not what happened. The common sense that tells you if he really was soft, didn't know how to fight, in his own words, he wouldn't have been able to get wrist control of Trayvon Martin. Those were his words. He wouldn't have been able to move his hand off his mouth or off his gun. If Trayvon Martin was putting on such a blow, that little plastic, flimsy kid's watch on his wrist, it wouldn't have come off. It didn't. The common sense that tells you, if Trayvon Martin was the one on the hunt, would he still have been on his cell phone? Would the earbuds still have been in his ears if he was getting ready to attack somebody? Really? And the most important one of all, the common sense that tells you in your everyday life, really, if he hadn't committed a crime, why did he lie so many times? Why did he lie? Let me remind you. Sean Nofke told me to get an address. That didn't happen. Listen to the tapes. Listen to the walkthrough and listen to the non-emergency call. Sean Nofke never said that. I told the police I was going to meet him at my car. That's not what he told them. Why? Why lie about that? It's so important, that's why. Because he wasn't going back to the car. He was going back to Trayvon Martin. Just like he said on that tape when he slipped up. Just like he lied about when he was confronted. It wasn't 10 seconds afterwards. It was 2 minutes. Trayvon Martin covered his mouth and nose. Really? They want you to believe that the blood was washed off by incompetent medical examiners. But yet he told the police, not just the police, his best friend, remember his best friend in the world, that Trayvon Martin was squeezing his nose. Do you really think if that were true, there wouldn't be George Zimmerman's blood on these sticks that they pried under his fingernails? Do you really think that's true? That was a lie. Concrete. You're kidding me. It's heavy. It's hard. If his head had been slammed into something like this, slammed, bashed over and over, he wouldn't look like he did in those photographs. Think about it. That would be it. Dozens of times, he said. Dozens of times. Punch in the face. That would be it. Was he injured? Yes. Was he injured seriously? Not close. Not close. I mean, they can call their expert and show him all the pictures of the lumps on his head. Were any of those serious? Didn't Trayvon Martin have a right to defend himself too? Remember Lindsey Fulgate? He didn't have so much as a headache the next morning. Not nausea, not vomiting, not a headache. And he didn't come to see me for treatment. He came for a note for work. It wasn't that bad. It wasn't bad at all. Would Trayvon Martin's hand look like that if he had been pummeling him? He said Trayvon Martin saw his gun. First of all, it was inside his waistband. Inside. Second of all, Trayvon Martin's legs were covering it. He couldn't have got to it. Trayvon Martin couldn't have seen it. Do you think for a second, seriously, do you think for a second that if Trayvon Martin had seen that gun ever, there'd be a gunshot at 90 degrees in the center of his chest? Do you think that? I mean, Mr. Stay Puft, Mr. Softy, was going to be able to get a shot directly through the center of his chest with Trayvon Martin knowing that gun was there, fighting for his life? Do you think that? Why was it so important to say he spread his arms out? Because he had to make Trayvon Martin menacing, violent, threatening. So I had to put his arms out. They weren't. They weren't. They were not. They were clutching the bullet wound on his chest. The car. He had to make him sound menacing to justify what he had done. listen to those tapes again. There's the only two you have to listen to. The walkthrough and the non-emergency. Play them side by side right after each other. It's physically impossible, the way he told the police, impossible, that Trayvon Martin ran behind those homes, came back and circled his car. Why is he lying? He didn't want to know about Stand Your Ground. Didn't want the police to know he knew about it. Stand your ground? What's that? And let me suggest to you, in the end, this case is not about standing your ground. It's about staying in your car like he was taught to do, like he was supposed to do. And he can't now cloak himself with the noble cause of a neighborhood watch coordinator, violate its cornerstone principle, and expect you to absolve him of his guilt. He changed the story. This is where he told Detective Singleton he first saw Trayvon Martin. And this is where he showed him on the walkthrough. Watch the walkthrough again. Why did he lie about that? Why was it important that he came in through that cut like everybody else he had told the police? That he came through the cut because he had to make Trayvon worse. Had to make him worse, more menacing. That's why he lied. He told some people Trayvon Martin said one thing, and then it got worse. He told him he said something else. He reached for my gun. Had to make it worse. So he told Mark Osterman, his buddy, no, he grabbed my gun. He told him between the hammer and the back. Why? Why is he doing this? Told Mark Osterman he circled his car at the clubhouse. He told the police he circled it where he finally parked his car. He never circled his car. Told somebody he got his cell phone out. Told other people he was reaching for his cell phone. That's what he was taught. Don't be a vigilante. Don't. See and call. Don't get out. Don't follow. Don't pursue. Don't try to detain. Just call. Just call. And they gave him a little special book. As the coordinator, what not to do. What did he do? And think about this. The defense referred to George Zimmerman as a responsible gun owner in their opening remarks. A responsible gun owner. What did he do after the shot was fired? Did he yell for an ambulance? Call 911? Get an ambulance here? I had to shoot somebody? Did he roll Trayvon Martin onto his back so he could breathe? He just stood there and he watched and he waited while Trayvon Martin was face down. The bottom line is, who is responsible for Trayvon Martin lying on that ground? Trayvon Martin didn't kill himself. And who's responsible for the state not being able to ask Trayvon Martin to step forward so I could put my hand on his shoulder? I'd love to do that. Who's responsible for that? And Trayvon Martin is not, was not, will never be a piece of cardboard. To the living we owe respect, but to the dead we owe the truth. It probably seems like a year ago that we were all in here, one by one, and then as a group, in jury selection. And one question got a smile from everybody, but it's important. When the attorneys asked you, do you understand? It's not like TV. It was an important question, because it's not. And now you know, it's not like TV, where all the witnesses are well-dressed, well-educated actors and actresses. There are no Rachel Gentels on CSI. And they don't call people like Kristen Benson, who found nothing and a fingerprint from the gun on Law & Order. It's not like that in real life. In real life, we give you everything. The good, the bad, the indifferent. Because when that defendant is entitled to a trial, he's entitled to a fair one. All of it. All of it. And now you have that. In Hollywood, they write it up the way it happens on Sunset Boulevard. But in real life, it happens just like it did on Twin Trees Lane, in front of so many good, unsuspecting people. And remember, if you get back there and you don't like some of the witnesses in the case, you don't like Rachel Gentel or Shipping Bow, or the fact that there isn't this evidence, or the fact that there isn't that evidence, ask yourself, who produced this trial? Who made up the witness list? Who created the evidence? Who chose the circumstances? Who chose the lighting? Who chose the time? Who chose the weather conditions? It wasn't me. It was the defendant. He chose everything. And that's why we're here. And that's why the evidence is what it is. But it is enough with your common sense. It is enough. And I'm not asking you to fill gaps. I'm asking you to do what you do every day. Start from the beginning. Get to the end and apply your common sense. And don't misunderstand me. Your verdict is not going to bring Trayvon Benjamin Martin back to life. Your verdict is not going to change the past, but it will forever define it. So what is that? What is that when a grown man, frustrated, angry, with hate in his heart, gets out of his car with a loaded gun and follows a child, a stranger, in the dark, and shoots him through his heart? What is that? Is that nothing? That's not anything? Is that where we are? That's nothing? Well, that's not his call, and that's not my call. That's your call. And I submit to you, the oath you took requires it. Trayvon Martin is entitled to it And that defendant deserves it. Defense counsel went through this with you. I just want it real quickly because it is our burden. So indulge me, please. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm. I mean, they can put this picture up. You know, they blew it up for you. It's bigger than life size. It's color. That's the fact. That's reality. That's what he looked like that night. When you wipe the blood away, that's what he looked like. Did that man need to kill somebody? Need to kill a teenager? They put up pictures of all the witnesses. They forgot that one. Defense attorney said in his, well, ask yourself, you know, if there's an issue about who lost the fight, ask yourself, who lost the fight? Who lost the fight? Who lost the fight? That's all evidence. Those are all facts. In deciding whether George Zimmerman was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. He was, they estimated, 18 feet away from John Good. He knew the police were on their way. He knew that people were opening their windows and opening their doors. And when he shot him, he knew Trayvon Martin wasn't on top of him, so he could get his gun. Under those circumstances, under our circumstances, did he really need to shoot? Did he have to shoot Trayvon Martin? No, he didn't. He did not. Before I get to reasonable doubt, let me just go through a couple of things in the time I have remaining that the defense mentioned to you. I wrote down a quote. He said, "Innocent itself is no protection." Exactly. It wasn't for Trayvon Martin. He said he could have gone home. The guy could have gone home. In the same sense, he says, I guess, it seems. Why didn't he go home? Use your common sense. Did he really want to take this guy home with him to the residence where the only person there was 12-year-old Chad Joseph? Did he really want to lead the defendant to that residence? Just like the defendant said, remember? On the phone call, the non-emergency call, I don't want to give out my phone number. Why? Dennis Root said there's no other option for the defendant. For everybody else there is. I mean, he had to admit that. He could have done other things, but he said for the defendant, there wasn't another option. But consider this. This is so important when you consider his opinion. The only evidence he had about what was happening at the time the shot was fired was from who? Self-serving statements from the defendant. That was his opinion based on that. And when I asked him, when I got on the floor, how could he get the gun with Trayvon Martin on top of him? The words were, somehow. Like I said, if y'all have to do it, get on each other. You won't get the gun. You won't until you get off. Why give so many statements, the defense attorney asked. If he was guilty, why would he give any statements? Why give so many? Because he had to justify his actions, and that's why it kept getting worse. That's why by the time he got to Mark Osterman, it was completely different. That's why it kept increasing. That's why when he got to Sean Hannity, wow. It was God's plan. By the time he got to Sean Hannity, it was God's plan. The defense attorney mocked me. That's fine. Because I said he pushed the gun into his chest. He didn't. He didn't. It was a contact wound with his shirt. He didn't push the gun into his chest. A reasonable doubt is not a possible doubt, and a speculative doubt, an imaginary doubt, or a forced doubt. And it's kind of funny the way they do the instructions. They don't tell you what a reasonable doubt is. They tell you what it's not. But let me suggest to you, a reasonable doubt is something you can attach a reason to. Use this definition as guardrails for your deliberations. If you get back there and one of you says, well, maybe this happened, or couldn't this have happened, or isn't it possible this? That's not a reasonable doubt. A reasonable doubt needs to be two things. It needs to be reasonable, common sense, reasonable. And it needs to go to an element of the crime. If you have a question about something that doesn't go to an element of the crime, and Judge Nelson's about to spell those out for you, probably after the lunch break. If it doesn't go to one of those elements, it's not a reasonable doubt. A reasonable...
Sorry, I apologize. I need to interrupt and approach the bench maybe for a moment.
Okay.
Or I can state it now.
No, approach the bench. Ladies and gentlemen, again, after the final arguments have been concluded, I will instruct you on the law that's applicable to this case. You will be taking that law back to the courtroom with you. Thank you. You may proceed.
Thank you, Judge. Listen to the court when you get the law. This is what she'll tell you. A non-reasonable doubt, something that's not reasonable, possibility, imaginary doubt, or forced doubt, must not influence you to return a verdict of not guilty. Let me just address one more thing with you before I close. And that was, it was brought up actually by the defense. It was brought up by the defense in their summation this morning, and it was brought up by the defense in the trial. Not by the state, but by the defense. Race. This case is not about race. It's about right and wrong. It's that simple. And let me suggest to you how you know that for sure. Ask yourselves, all things being equal, if the roles were reversed and it was 28-year-old George Zimmerman walking home in the rain with a hoodie on to protect himself from the rain, walking through that neighborhood, and a 17-year-old driving around in a car who called the police, who had hate in their heart, hate in their mouth, hate in their actions. And if it was Trayvon Martin who had shot and killed George Zimmerman, what would your verdict be? That's how you know it's not about race. To the living, we owe respect. But to the dead, we owe the truth. What do we owe Trayvon Martin? 16 years and 21 days. Forever. He was a son. He was a brother. He was a friend. And the last thing he did on this earth was try to get home. This is the dead. The self-serving statements, the lies from his own mouth, and the hate in his heart. Words that they can't now take back. The physical evidence which refutes his lies. And the law that Her Honor is about to read to you, the law that applies to all of us, and the law that applies to each of us. This is the truth. Thank you for your time.
Ladies and gentlemen, I'm going to read the jury instructions, but I want to give you a choice. Would you like to have these instructions read after lunch, or would you like to have them read now and then go to lunch? After lunch? Okay, I will respect that. Please put your notepads down. Before you go to lunch, I want to admonish you again. You are not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or terminology. And finally, you're not to read or create any emails, text messages, tweets, social networking pages, or blogs about the case. Do I have your assurances that you will abide by these instructions? Okay, thank you. We'll be in recess until 2 o'clock. If you'll please put your notepads face down. Please be seated. If counsel will approach the bench for a moment. Can you turn your wait? Court is in recess until 2 p.m. Please be seated. We're back on the record. Is everybody ready for the jury to come in? Yes, Your Honor. Did you all work on the exhibits that are go back and it's agreeable it's all in order?
Care of it.
Okay, perfect. All right, let's bring the jury in. For those of you seated here, during my reading of the jury instructions, nobody will be allowed to come in or come out. If you don't want to sit throughout the jury instructions, the time to leave would be now. Nobody's jumping up.
present, Your Honor.
Please be seated. Ladies and gentlemen, while you're getting settled in, I'm going to ask you my questions. If your answer is yes, please raise your hand. During the lunch recess, did any of you have any discussions amongst yourselves or with anybody else about this case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, tweets, blogs, or social networking pages about the case? Thank you very much. This time, ladies and gentlemen of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I am about to give you. The packet from which I'm reading will go back into the jury room with you, so you don't need to take notes. George Zimmerman, the defendant in this case, has been accused of the crime of second-degree murder. In this case, George Zimmerman is accused of second-degree murder, a killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Trayvon Martin was killed by George Zimmerman, you will then need to consider the circumstances surrounding the killing in deciding if the killing was murder in the second degree or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon George Zimmerman, or to commit a felony in any dwelling house in which George Zimmerman was at the time of the attempted killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before George Zimmerman may be found guilty of second-degree murder or any lesser crime. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Trayvon Martin is dead. 2, the death was caused by the criminal act of George Zimmerman. 3, there was an unlawful killing of Trayvon Martin by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another and is done from ill will, hatred, spite, or evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove George Zimmerman had an intent to cause death. If you find that George Zimmerman committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm to or the death of Trayvon Martin, you should find George Zimmerman guilty of second-degree murder with discharge of a firearm causing great bodily harm or death. If you find that George Zimmerman committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find George Zimmerman guilty of second-degree murder with discharge of a firearm. If you find that George Zimmerman committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find George Zimmerman guilty of second-degree murder with actual possession of a firearm. A firearm is legally defined as any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. To actually possess a firearm means that George Zimmerman carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that George Zimmerman committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if George Zimmerman is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder is manslaughter. The killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon George Zimmerman, or to commit a felony in any dwelling house in which George Zimmerman was at the time of the attempted killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Trayvon Martin is dead. 2, George Zimmerman intentionally committed an act or acts that caused the death of Trayvon Martin. George Zimmerman cannot be guilty of manslaughter or committing a merely negligent act, or if the killing was either justifiable or excusable homicide. Each of us has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon George Zimmerman, or to commit a felony in any dwelling house in which George Zimmerman was at the time of the killing. The killing of a human being is excusable and therefore lawful and under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. In order to convict a manslaughter by act, it is not necessary for the state to prove that George Zimmerman had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable and which caused death. If you find George Zimmerman committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the manslaughter, George Zimmerman carried, displayed, used, threatened to use, or attempted to use a firearm, you should check the appropriate box on the verdict form, which I will discuss with you later in these instructions. The definition of firearm has previously been provided in these instructions. An issue in this case is whether George Zimmerman acted in self-defense. It is a defense to the crime of second-degree murder and the lesser included offense of manslaughter if the death of Trayvon Martin resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. In deciding whether George Zimmerman was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing George Zimmerman need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, George Zimmerman must have actually believed that the danger was real. If George Zimmerman was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. In considering the issue of self-defense, you may take into account the relative physical abilities and capabilities of George Zimmerman and Trayvon Martin. In your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether George Zimmerman was justified in the use of deadly force. You should find George Zimmerman not guilty. If, however, from the evidence you are convinced beyond a reasonable doubt that George Zimmerman was not justified in the use of deadly force, you should find him guilty if all the elements of the charge have been proved. George Zimmerman has entered a plea of not guilty. This means you must presume or believe George Zimmerman is innocent. The presumption stays with George Zimmerman as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome George Zimmerman's presumption of innocence, the state has the burden of proving the crime with which George Zimmerman is charged was committed, and George Zimmerman is the person who committed the crime. George Zimmerman is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt should not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find George Zimmerman not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of George Zimmerman may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find George Zimmerman not guilty. If you have no reasonable doubt, you should find George Zimmerman guilty. The state must prove that the crime was committed on February 26, 2012. It must be proved only to a reasonable certainty that the alleged crime was committed in Seminole County. It is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is only reliable when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The Constitution requires the state to prove its accusations against George Zimmerman. It is not necessary for George Zimmerman to disprove anything, nor is George Zimmerman required to prove his innocence. It is up to the state to prove George Zimmerman's guilt by evidence. George Zimmerman exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that George Zimmerman did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by George Zimmerman outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that George Zimmerman's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether, when George Zimmerman made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude George Zimmerman's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Excuse me. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if George Zimmerman has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if George Zimmerman is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. During this trial, I have permitted you to take notes. You will be allowed to take those notes into the jury room during deliberations. You are instructed that your notes are a tool to aid in your individual memory. You should not compare your notes with those of other jurors in determining the content of any testimony or in evaluating the importance of any evidence. Notes are for the note-taker's personal use in refreshing his or her recollection of the evidence. They are not evidence. Above all, your memory should be your greatest asset in your recollection of the evidence. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find George Zimmerman guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to the crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary form of verdict has been prepared for you. It is as follows. It reads at the top, in the Circuit Court of the 18th Judicial Circuit in and for Seminole County, Florida, case number 2012 CF 1083A, State of Florida versus George Zimmerman. Verdict. Under the word verdict, there are 3 lines. Next to the first line, it reads, we, the jury, find George Zimmerman guilty of murder in the 2nd degree as charged in the information. Next to the second line, it reads, we, the jury, find George Zimmerman guilty of manslaughter, a lesser included offense. Next to the third line, it reads, we, the jury, find George Zimmerman not guilty. You're to place an X on the line that reflects your verdict. Under that, it says special findings. If you find George Zimmerman guilty of murder in the 2nd degree, you must choose one of the following. There are 4 lines. Next to the first line, it reads, we find that George Zimmerman discharged a firearm causing death or great bodily harm to another during the commission of this offense. Next to the second line, it reads, we find that George Zimmerman discharged a firearm without causing death or great bodily harm to another during the commission of the offense. Next to the third line, it reads, we find that George Zimmerman actually possessed but did not discharge a firearm during the commission of the offense. Next to the fourth line, it reads, we find that George Zimmerman did not actually possess or discharge a firearm during the commission of the offense. If you find George Zimmerman guilty of manslaughter, you must choose one of the following. There are 2 lines. Next to the first line, it reads, we find that George Zimmerman carried, displayed, used, threatened to use, or attempted to use a firearm during the commission of the offense. Next to the second line, it reads, we find that George Zimmerman did not carry, display, use, threaten to use, or attempt to use a firearm during the commission of the offense. You're to put an X by the appropriate line if you so find. So say we all, a line for the foreperson to sign and to date. In just a few moments, you will be taken to the jury room by the court deputy. The first thing that you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. If you need to communicate with me, send a note through the court deputy, signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. Your verdict finding George Zimmerman either guilty or not guilty must be unanimous. The verdict must be the verdict of each juror as well as the jury as a whole. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. At this time, if all of you will please take your notes with you and follow Deputy Jarvis back into the jury. Yes, just 1 minute. Yes, you may. Is there any, just so everybody knows, the alternates E54, E13, and E28 have been separated, have not gone back with the jurors, and they will be discharged given their proof that they've been here on this jury all the time to bring back to their employers. Is there anything else we need to take up before we recess? Okay, counsel, if you'll please leave your phone numbers with the clerk. All the evidence is there. Bobby Ray, you need to take these instructions, a verdict form. About the gun, I don't want to send the bullets back. Any objection to sending the gun after it's been once more cleared by the court deputy and the lock been put back on it?
No objection, Your Honor, and no objection to leaving the ammunition inside.
The ammunition will not go back. Okay? All right. Thank you very much. Court is in recess. Please be seated. We're on the record. We have it's in the form of a request from the jury. It says, is there an inventory list of the evidence by number and description? So I know that the clerk keeps the evidence record, but it also has on there the items that are identified for the letters for identification purposes only. Susan, is there a way to create just a what's in evidence list?
We can just print that out, work it out.
You could do what? Print it out?
We can just
White it out and make a copy? So if counsel wants to approach the clerk and see what it is that she's proposing and tell me if you have any objections, you can look at the question if you want, but that's exactly what it says, what I read. You could give it to them and they can look at it. You could give that to Susan. She needs to file it in the court file. Su-
These are not the ones introduced? My only concern is where's the 14? You just show me an example. What have you done? My answer is,
And Susan, the jury question, if you'll please put it under seal for now.
You want the attorneys to be able to?
Yeah, they can see it, but then when you take it, please file it under seal for now.
Thank you. Thank you very much.
Okay, counsel, if you'll still just remain here, we're going to recess so the clerk can go ahead and make that, and when she's ready, I'll come back in the courtroom to make sure you review it, and then if there's no objection, I'll just have the deputy bring it into them as a procedure. Okay, we'll be in recess for a few moments. Please be seated.
Because I'm confused. I'm saying, this is yours. What? No, I'm sorry. Sorry. No, I got it. Okay. So this is all ours, right here. And then this is all the states. Right. And you just made a copy that's got.
You made 6 copies.
Oh, do not cross tape, right? The investigator. Yes. Yeah, you're right. So, Anderson, very much appreciate the work. And you have 6 copies? Oh, this
Okay. Is the exhibit list that has been prepared by the clerk acceptable to the state,
It is, Your Honor.
to the defense?
Just a moment to make sure that my client. Thank you very much, Your Honor. Yes, they are.
Okay, any objections to the 6 copies being provided to them from the Deputy Jarvis, or do you want me to bring them in the courtroom and
We're
give it to
fine
them?
with it being delivered, Your Honor.
We agree, Your Honor.
Okay, thank you. We'll go ahead and have those 6 copies delivered, and we'll be in recess.
We
Yes.
should have asked this before, so we don't need it right away, but just for our purposes, can we get a couple of copies? I think we'll probably want one of what was sent to them. Great. Doesn't need to be right away. Next time, you have to make copies or something.
Okay, thank you. Court will be in recess. Please be seated. We are back on the record. This is from the jury. It says the jury would like to adjourn tonight, 5:50 at 6 p. Well, the notes at 5:50. Let me reread it. The jury would like to adjourn tonight at 6 p.m. The jury would like to begin tomorrow at 9 a.m. if possible. Anybody have any objections?
No, Your Honor.
No, thank you, Your Honor.
Okay, what I'm going to do is bring them in here and give them their admonishment and release them until 9 a.m. Okay? Okay, let's go ahead and bring them in.
begin their deliberations?
I will bring them in the morning as well because I want to make sure that they hadn't had discussions.
Yes.
Yeah.
Thank you.
Is there any question, Your Honor?
Please be seated. Good afternoon, ladies and gentlemen. We're going to go ahead and adjourn for the day, so you will be going into recess overnight. I just want to give you my admonitions before you recess for the evening. During the overnight recess, you're not to talk about the case amongst yourselves or with anybody else. Although you are in the deliberation stage, your deliberations are only going to occur while you're here in court in the jury room. So do not discuss the case amongst yourselves or with anybody else overnight. Do not read or listen to any radio, television, or newspaper reports about the case. Do not use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or terminology. And do not read or create any emails, text messages, tweets, blogs, social networking pages about the case. Your notes will be locked up in the jury room. You will not be allowed to take them back with you. They will be there available for you in the morning. We will recess until 9 a.m. At that time, I will bring you back into the courtroom so we can begin court and then have you go back and recess. Will all of you abide by the instructions that I have given you? Okay, with that, please follow Deputy Jarvis. Okay, is there anything, please be seated. Is there anything else that we need to take care of before we recess for the evening?
No, thank you.
Okay, thank you very much. We'll see you at 9 a.m.